Funny. Yeah, it's sad.
Okay, running just a few minutes late. We apologize for that. Had a little bit of a long study session there. But we're ready to call to order the October 26th, 2015 meeting of the Salina City Commission to order, and we'll start with a roll call, please.
Mayor Blanchard.
Here.
Commissioner Crawford.
Here.
Commissioner Davis.
Here.
Commissioner Hardy.
Here.
Commissioner Ryan.
Okay, at this time, I would ask that all of you who are able to please stand and join us in the Pledge of Allegiance in a moment of silence. Okay, thank you. Okay, we're going to start out with awards and proclamations.
Item 3.1, the day of November 1, 2015 is Extra Mile Day in the city of Salina. George Troutfetter, Advisory Council Co-Chair, will read the proclamation.
Okay, Mr. Troutfetter, welcome. I like that shirt.
Yeah, I've worn this for a while. Thank you, Mayor Blanchard. Proclamation of the City of Salina, Kansas. Whereas Salina, Kansas is a community which acknowledges that special vibrancy exists within the entire community when its individual citizens collectively go the extra mile in personal effort to address needs through volunteer service. And whereas Salina, Kansas is a community which encourages its citizens to maximize their personal contribution to the community by giving of themselves wholeheartedly with total effort, commitment, and conviction to the betterment of self, family, neighborhood, and community. And whereas Salina is a community which chooses to spotlight and celebrate individuals and organizations within its community who go the extra mile in order to make a difference and lift up fellow members of their community. And whereas Salina, Kansas acknowledges the mission of Extra Mile America to create 550 Extra Mile cities in America, and it's proud to support Extra Mile Day on November 1st, 2015. Now therefore I, John Blanchard, Mayor, do hereby proclaim November 1st, 2015 to be Extra Mile Day in Salina, Kansas. I urge each individual in the community to take time on this day to not only go the extra mile in his or her own life, but also to acknowledge all those who inspire others through their efforts and commitment to make their families, organizations, community, country, and world a better place. Signed this 26th day of October, 2015.
Okay, thank you, George. Can you tell us, are there any special events or anything planned for the first?
Well, I don't know about the first, but we are going to recognize the 29 active RSVP volunteers who are veterans of the military service following the annual Veterans Day service at Sunset Park on November 11th. So we are going to do that.
Okay, that's great. 29 veterans at the Veterans Day
That serve
celebration following.
right on the RSVP volunteer.
That's great. Well, first of all, I'd like to thank you and your co-chair, Mr. Gary Hobby, for the work you do there. Also, Amy Adams, who is your secretary, and also Clay Thompson, your past chairman. So, and also like to give a very big thank you to Nancy and her staff. I have a signed proclamation for you, and then I have a little something to add to this after. Okay, as part of the Extra Mile America that George had mentioned, and the proclamation is, I received an email from Nancy Klostermeyer from Volunteer Connection, and I'll just read what this had asked, and It stated that mayors may submit 1 to 5 names of amazing extra mile people and/or organizations that are making significant contributions to make the city better. These people and organizations will be included on their website, and their names will be sent to the White House as an extra mile change makers whose service truly stands out and deserves to be recognized. And they want photos too, if possible, so we'll have to do this later. But they wanted to, Nancy asked that maybe if I had an inkling to add 1 to 5 names or organizations, that I give that some thought, and so I did that. And I came up with 5 individuals and organizations, actually 3 individuals and 2 organizations that I would just, if you guys will indulge me, I'd like to read these. And they are the Extra Mile Change Makers, and I believe we do this is this done every year? And so everybody that comes into this chair, I hope you'll get the same opportunity, because as I went through it, I realized that I'm leaving off dozens and dozens of names and organizations, but I went to top of head and top of mind on this for myself, and so I'll share these with you. I had 5. I'll do the 3 individuals first, and first is Barb Young with the North Salina Community Development Group. And Barb has been the president of the North Salina Community Development Group for the past 4 years. Barb has led North Salina Community Development from a small group of concerned citizens wanting to improve living conditions for North Salina residents to a grassroots nonprofit organization that has contributed to several community building projects, such as 2 North Salina Planning and Visioning workshops, a community engagement collaboration with KSU Salina, Kansas Wesleyan University, and Salina Tech, the Faith for the Cure sponsorship, many fall and spring spruce up cleanup efforts, food distribution projects, farmers markets, food trucks, and the effort to have a neighborhood grocery store open on East Iron. As president of North Salina Community Development, Barb also coordinated efforts for many beautification projects in North Salina, notably the 5 Corner Sculpture and Rain Garden, landscaping and sculpture on North Santa Fe at Chuck's Bar, and the landscaping and sculpture project in progress at Hawthorne Park. Barb can often be seen driving a front-end loader the extra mile. Second I had here was Brenda Gutierrez with the Salina Area United Way, also known as Miss Everywhere. Brenda has a way of being anywhere something good and positive is happening. Brenda is a strong advocate for many things, including summer meals and reading for kids, early childhood development, farmers markets and food advocacy, many North Salina projects, quality and equitable bus service. She did quite a bit on the working to get the CityGov 5th route, and many much more. Brenda is always going the extra mile. The third individual is Barb Good, and Barb is with the Kansas State University Pollution Prevention Institute. If there were a burning the extra midnight oil award, Barb would win that. Barb is simply the go-to person for many who are looking for help finding grant dollars or other funding sources, large or small, with limited information and usually on a tight deadline. Some of the efforts that have benefited in large part to Barb's efforts are an EPA planning grant and consultants for North Salina, a rain barrel project, radon detection projects, sustainability and prevention, pollution prevention projects, food security and advocacy, farmers market, and many things in North Salina. Barb tirelessly goes the extra mile. First group I'd like to recognize is the Greater Salina Community Foundation. The vision of the Greater Salina Community Foundation has been to multiply the impact of charitable giving by connecting community members, nonprofits, and other partners to look forward to a brighter future. The foundation is currently the largest community foundation in Kansas and serves the needs of hundreds of nonprofits, initiatives, and funds throughout the Greater Salina area and north central Kansas. The staff and donors of this Greater Salina Community Foundation consistently go the extra mile. And last but certainly not least is the volunteer connection. Whether it be a fall fix-up, spring spruce-up, or a need for 2 to 3 volunteers for a small event, the volunteer connection can always be counted upon to provide cheerful, willing workers for community projects. The staff, board, and army of volunteers at the Volunteer Connection continually go the extra mile. in their work and help provide opportunities for residents of Salina to go the extra mile in service to our community through volunteerism. So thank you to all of the individuals and group. A special thank you to the Volunteer Connection for the proclamation and bringing this Extra Mile America to us and giving us the opportunity to recognize the many, many people that are involved in volunteerism in the city of Salina. So thank you to you all. And thank you for your indulgence. Okay, we'll move on to Citizens Forum, and this is a time for any citizen to come up to speak to any issue not on today's agenda. And we only ask that you leave your name and address and keep it to under 5 minutes, please. So we'll open Citizens Forum at this time.
I'll think I'm on the agenda for the day. George Meinhardt, 136 Bel Air, here in reference to 906 North 11th. I was just wanting another 30 days or so to get contractor in there and get them going on that and not have it bulldozed pretty much. I just got the check in the mail today. I can show it to you if you'd like.
Okay. What we have, commissioners, here is just another a follow-up on some of the dangerous structures that we've had in the past. So much like next week, I would recommend that maybe we just add this to the end of the agenda, and unless there's an objection at this point.
So moved.
Okay.
Second.
We'll go ahead. What we'll do is we'll add this at the end of the meeting
That's fine.
to the agenda. And do you want to add it now, or is that what your intention was?
There's a motion.
To add it now?
Motion
I
just
think
to
so.
add it at the end.
Okay.
Yeah, it would be best to go ahead and vote to add it.
Okay. Let me find my.
Here you
Here we go. Okay. Our last order of business today is 8.1B. So would we want to make this 8.2?
Or is it a 7-point?
I'm looking to Shandy. Or would you want to make it
7-3.
7.3? Okay. Well, okay, we'll add it to 7.3 and we'll do it in that order. Okay.
All right.
So I have a motion and a just a second on the address on that again.
906 North 11th.
906 North 11th.
Meinhardt.
Okay. And this would be an extension, a request for an extension. Would that be?
Yes, sir.
Greg? Mike?
Yes, that's.
Okay.
Sure.
Okay. So. Correct me if I'm wrong, but I have a motion and a second to add item 7.3, consideration of an extension to I don't have a resolution number, but if you can get me a resolution number that we're extending. Okay.
Will be resolution 157213.
Okay, extension to an extension on resolution 15-7213 in reference to the dangerous structure located at 906 North 11th. Okay. All in favor?
Aye.
Opposed? Okay, that will now become item 7.3.
Okay.
So,
So I need
okay.
to stick around then, or?
Yeah, you'll want to stick
Okay.
around till we bring that up on an item. Thank you.
Ray Huska, 235 North Santa Fe. Good afternoon, Commissioners.
Good afternoon.
Kind of cool day out today. That's fine. This is about being an American. I think we're all covered there. We're all Americans. It is my right to be uncommon if I can. I seek opportunity and not security. I do not wish to be a kept citizen, humbled and dulled by having the state look after me. I want to take the calculated risk to dream and to build, to fail and succeed. I refuse to barter incentive for a dole. I prefer the challenges of life to the guaranteed existence, the thrill of fulfillment to the stale calm of utopia. I will not trade freedom for beneficence or my dignity for a handout. I will never cower before any master except God, nor bend to any threat. It is my heritage to stand erect, proud, and unafraid, to think and act for myself, enjoy the benefits of my creations, and face the world boldly and say, I have done. I do not choose to be a common man. And I wish to thank the commission for the privilege to present this.
All right, thank you.
Thank you,
Mayor and Commissioners.
Is this allowed? Mr. Stack.
Yes, thank you. I've had a few questions about Iron Street over the last few weeks and months, and I know just thought I'd at least talk about that a little bit today, just to say where we're at.
Okay.
And that's east of Delaware, all the way up to Marymount Road. And yes, it was a little bit experimental. We've had good success with microsurfacing here in the city for a long time, but it has its limitations, and that was a road that we thought the milling would help us. It actually probably made it worse. It just seemed to have, the old asphalt was over concrete. The concrete is 1951 construction, so it's 60 years old plus, and quite a few asphalt overlays over the years. Micro is roughly half the cost of microsurfacing is half the cost of asphalt, so okay, you can make your money go farther with that type of approach if you can mill it and get it smooth. So we knew we were in trouble when we milled it, and it was it was just tough to get the milling smooth. The road had enough undulations in it. The asphalt didn't stick to the concrete very well, so it came off somewhat in chunks in some places. So we had to try to fill it back in with micro, and that's not maybe the best application for that. Thought we could do a leveling course and a couple of coats, and we could make it work. Well, as everybody knows, it didn't work very well. So that's where we're at, and we are going to look at trying to overlay it. And I guess the hope is that we would have had to do a leveling course and then an overlay as well with an overlay. So in this case, we can count our micro as our leveling course. Hopefully it's leveled it enough to where a final lift of asphalt will make it good. And that is so the hope would be we're not out a whole bunch of extra money, I guess. If we'd have spent this much in asphalt to begin with, it would be about what we're going to do now. That's the hope. But we still have to talk to APAC and our overlay contractors to see if they can get it in this year. And maybe even at the same, we have a contract with them now, so at the same rate would be a pretty good deal for us. Wouldn't have to go back and renegotiate prices, and oil is kept at the same level, so we hope that they would do that, but they may not, so we'll have to see where we end up. We'll get her fixed. I drive it every day. It's in front of my home, right by my house, so I have a lot of people who've asked me about it. Thank you.
All right. Hey, thanks for the update. And I think it just, we appreciate the effort to find where we can cost savings. And 9 times out of 10 we're successful, and sometimes it just doesn't work out exactly like. But it's the remedy is there's a remedy, and we can make it right, and we'll just do that. But I just want to encourage staff to continue to look at innovative ways that we can find cost savings on things, and don't be discouraged by sometimes if it doesn't always work out. So I appreciate that, and I think it's a lot more important how we fix problems that don't always go right than just letting them go and trying to forget about them. So I appreciate you addressing that.
And Dan, what you hear are all the complaints. You don't hear all the other streets that are lots better, and they don't tell you that. So,
Right, I think we do a great job on streets, so I agree. Okay, is there any more public comment at this time? Okay, well, thank you all for your comments, and we'll move on to public hearing and items scheduled for a certain time.
Item 5.1, hearing for owners of 623 North 13th Street to show cause as to why the structures should not be demolished on the basis that the owners have failed to diligently prosecute the repair or removal of dangerous conditions pursuant to resolution numbers 15-7209 and 15-7258.
Okay, first thing, we'll open the public hearing at this time, and we'll receive a staff report or multiple staff reports from, I have Jim Brown on here, but I suppose there might be a tag team.
That's as good a place to start as any.
Okay, Mr. Brown.
Thank you, Mayor, Commissioners. This afternoon, we're bringing this hearing for the owners at 623 North 13th. Show cause why the structure should not be demolished on the basis that the owners have failed to diligently prosecute the repair or removal of the dangerous condition pursuant to our resolutions 15-7209 and 15-7258. The purpose of the show cause hearing today is to provide the owners with opportunity to appear before the governing body and show cause why the structure should not be demolished on the basis of their failure to diligently perform the work as evidenced by the failure to apply for a building permit. Now, in your blue sheet, you'll see we provided you with a lot of information, a lot of history on this particular structure, which you're familiar with most of that as it is. And although the term diligently prosecute is not defined specifically in Kansas statute, Black's Law Dictionary does define diligent as being careful and attentive, persistent in doing something, industrious, assiduous, or carried out with care and constant effort. At this particular time, there is a pending injunction lawsuit, and we did provide you with a short summary of the facts and history related to this lawsuit, and that is included in your packet. Any specific questions related to the lawsuit, we ask that you direct those directly to our legal counsel, Mr. Bingston. And if the governing body directs city staff to proceed with the demolition on the basis of the owner's failure to diligently prosecute the work, staff requests that the order to demolish be conditioned upon the judge making no objections to the demolition at our October 28th hearing in the Saline County District Court. There will be cost, as we provided in the blue sheet in your packet, as for our demolition cost. We have identified two alternatives for the commission today. One, to order staff to proceed with the demolition of the structures located at 623 North 13th Street in accordance with resolutions number 15-7209, 15-7258, subject that no objections being received by the district court judge at the October 28, 2015 hearing, or two, to decline to order staff to proceed with demolition. And yes, this is going to be a cumulative effort between several staff members this afternoon.
Okay,
Any questions for me?
thank you for the update. Are there questions right now for Mr. Brown? No? Okay. Can we get an update, Mr. Bankson, on what where we are in the court? We know the court date is the 28th, but where are we in relation to that? And then what happens on that day that makes anything different than things are today?
Be happy to address that, Mayor. The court entered its order Mr. Miniman, who is present, has filed a motion to set that order aside. We did have the complicating factor of learning through Mr. Miniman's motion that the process server who served or who was charged with serving both Joseph Miniman and Jeffrey Miniman, by every indication, did not actually personally serve Jeffrey Miniman. And that's certainly an unfortunate complicator from the standpoint of just the whole situation. But the purpose of that suit seeking injunctive relief was to request an order of the court to stop the work that was being done on the property without any building permits and without regard to the city's contractor licensing requirements. That work stopped. So the primary purpose of the suit to stop that unlawful work has been achieved. The matter is before you today in relation to the city's role. We still have the resolutions that you have put in place. We still have the requirements that you have put in place. And we still are within the context of your discretion and your determination as to whether the work has been or is being diligently prosecuted under the resolutions, the series of resolutions that you have adopted in relation to this matter. We anticipate that that will be of interest to the court as the matter comes before the court again later this week. And that is what prompts both the point of your addressing the matter and giving the property owners this opportunity to explain or to show cause why no work or the work has not been performed, in anticipation of then advising the court of that determination at its hearing.
Okay. Now, this may be a question for you or Mr. Brown, and that is like during the whole process of, I mean, the legal work was done to say, you don't have a permit, stop, and make that happen. During that entire process, was there anything that would have prevented Mr. Minimum from obtaining a permit to demolition? I mean, did that lawsuit create a timeout to where there could be no application, or was it still possible? I mean, is it still possible to this day that a permit could be pulled for the demolition?
Oh, certainly. Throughout this entire time, that was, and in fact, the court addressed that. Now, we recognize again that there is that aspect in relation to Jeffrey Miniman in terms of the personal service in any order of the court. But, as I said, regardless, that opportunity has existed from the outset and was not affected in any respect by the order of the court. And in fact, the order of the court is consistent with that in terms of anticipating that there would be the pursuit of the work, whether it be to demolish or whether it be to rehabilitate the structure. It was just a matter of doing so with permits and with properly licensed persons doing the work.
Okay, because the timeline on this keeps growing, and I do know Was 7258 our last resolution? Was it the last resolution? It was July 13th. That was our last, wasn't it?
Yes.
Okay, and on that date, we had a number of things that we wanted to make sure were happening with the knowledge that this was in a dangerous, declared a dangerous structure. Part of this, I thought we wanted to make sure that at least the premises were safe and secure. Has that even happened, or is it still wide open?
I'd be more than glad to take that one. Mayor and Commissioners, we did secure the property with some fencing material around the structure itself. That has been removed since we have installed it ourselves.
Did we remove it?
No, we did not remove it.
Okay. Is there anybody else have questions for staff on this?
Is this the Jeffrey minimum situation? Is that the question that's going to be addressed by the court then on the 28th? Or is that a separate issue?
That matter will be addressed, I would anticipate, by the court at the hearing. But as I say, in terms of what you're asked to do today, that is unrelated.
Okay. All right. If we want to make this as simple as we possibly can here, we are just
Yeah.
right.
I think
Because it's an awful thick pack, and it's a very simple
Yeah.
thing that we're actually here doing. Is we're simply saying, has Resolution 7258 been adhered to? Yes or no? And do we move forward here with the order to demolish and then let the chips fall where they may when the judge orders it?
I think, Mayor and Commissioners, the key document for purposes of your consideration today, in addition to the blue sheet, is the order of the building official that maybe you noticed is the first item following the blue sheet. That essentially sets out the factual findings made by the building official that brought us to this point. And it does, you're correct, boil down to a single question, and that is whether the work, whether to rehabilitate or to demolish,
Right.
has been diligently prosecuted or not.
Okay. Any questions for staff at this time? Okay, we'll go ahead and open this up and allow the property owner and any other public comment at this time. Please, your name and address for the record, please.
Joseph Miniman. I have this property at 623, and I also live in Illinois. This is for your reading enjoyment. I don't think you will enjoy it after you read it.
Okay, thank you.
Thank you, sir.
Staff have a copy of this?
Mr. Miniman, would you like staff to look at it, Mr. Miniman? That'd be helpful.
Because when you read it, you misinterpret things.
Would you like?
Thank you.
Okay, thank you.
You see, I had an opportunity after all this went down.
Mayor, if I may, pardon me, Mr. Miniman, it would be helpful to have an opportunity to read what the commission has just been presented before hearing further comment. It's a little hard to read, and
I'm going to read it to you if you'd like.
if you're referring to the same document, that
Okay,
would be
well,
helpful. It would
we'll
be
read
helpful.
along and we'll read along with you, and we'll stop you if we need to have clarification if that.
Yeah, I'm sorry.
Go ahead.
If I may, I'd like to have a copy before we begin making reference to the document. And
Okay.
I think we're just
Go ahead.
moments away from that opportunity.
I thought I was supposed to be able to present objections.
Okay.
Do
Well,
I
you
have
certainly
to
are, and if you'll
approval
just-
first before I can present
Well, I'll
them?
tell you what we'll do is this.
I just want to be able to
We'll
follow
make
along.
a copy. I want to make a copy right now. I want to make a copy available to Mr. Bankson. I'd like you to have the opportunity to read that. So, why don't we take?
We can share.
Oh, I can follow along. I didn't mean to suggest that I had to As long as I've got one while we're going through it, that's
Okay,
fine.
well, I'll give you this one.
Well, then make a copy, because I'd prefer you read along with you, Mr. Mayor.
I will peek on yours with you.
Yeah, we'll share this one.
Okay. There's no open meetings violation if I read along, is there? Okay.
As long as you don't say anything.
Okay, thank you. All right, if everybody okay? All right, we'll go ahead.
October 26, 2015, that's the day. After receiving the journal entry order entered 7/23/15 that I received at the end of August that was entered without any evidence on a scheduled hearing for 7/11/15, as I had requested evidence to support the city's position. However, the court allowed the city to confess its petition and told the city to draft an order, and it will be signed, and it was. I sought legal advice. The background in this matter is that and now I receive a document entitled Findings and Order of the Building Official as to why I'm now here at the moment. That's why I'm here, because of that.
Okay.
The background on this matter is that on 4/27/15, the city adopted several resolutions covering several different residential dwellings, providing for repair or removal of dangerous structures and establishing a reasonable time with which to repair or removal of such structures, and such structures shall commence and be completed by invoking City Code Chapter 31, Article 6, Section 31-502 and 501.2 that provides a dangerous structure legal standard of proof in that any portion of a building has been damaged by fire, earthquake, wind, flood, deterioration, neglect, abandonment, or by any other causes to such extent that it is likely to partially or completely collapse or to be detached. This being the jurisdictional standard intent of the ordinance, with proof to the effect that needed to allow the city to invoke Kansas statutes 12-1750, etc., to raise or rehabilitate the structure in question if the landowners fail to either repair or remove the claimed dangerous structure the city is claiming as dangerous and unsafe. Dangerous and unsafe, according to the City Code, Chapter 31-502, is that which is dangerous to life, health, property, or safety of the public or the occupants of the structures. Report prepared on 9/18/14 describing different factors checklist that was used to justify the initial resolutions. However, the report did not find that the building was in any kind of state of collapse or partial collapse, and in fact the report stated and admitted otherwise that would be needed to meet the legal standard of 31-502 and did not include the detached garage on the property. The initial notice to me and my brother received set a hearing as to any objections to the proposed resolutions that were scheduled before the council on 4/27/15, which I alone attended and requested resolution be tabled, which was denied, and the resolution passed, stating that the work had to begin by no later than May 11th, 2015, and completed by no later than 6/11/15 as to not only the dwelling structure but also the attached garage. My legal counsel later told me that there is no deadline on any completion of any work, only to diligently pursue the matter. After this work began immediately and in earnest to consider factors to determine the economic feasibility of repair or to raise the dwelling structure, these options being me and my brothers, and not to include the garage as it was not found to be dangerous and unsafe. Work was progressing nicely as me and my cousin, who was assisting me in dismantling and preserving various parts for future use. Not long after that, the city comes out and told my cousin, I was not present at the time, that the work had to stop because of a lack of permit and had not been obtained from the city, and posted notices in a stop work order. After this, I set up an appointment with the city as to what permit I needed to stop work or to refer to in the International Building Code and the International Residential Building Code that the city has adopted, citing City Code Chapter 8, which I pointed out to is a construction, building, and new development, and left the meeting, and my cousin and I returned to work as to what would be decided regarding the dwelling structure the city claimed to be dangerous and unsafe, so as to invoke Kansas statutes 12-1750, etc. On 6/11, while continuing to check all relevant factors to which route to pursue, raise or repair, a woman representing to be a private process server handed me a verified petition for permanent injunction and abatement of a common nuisance, not a dangerous and unsafe structure violation, plus an application for a restraining order. She also handed me the same set of papers addressed to me and my brother, who was not present, at which time discovery of relevant factors regarding the dwelling structure stopped, and on 7/23/15, a journal entry order was entered against me and my brother, permanently enjoining us from not only denying us from doing any work, but now required us, in order to work on our own property, to hire a licensed contractor to do the work and to obtain a permit. Code Chapter 31 does not provide for any of this. After this, I consulted with council as to how a local governmental unit, and under these circumstances, can just take money or property by confiscation from me and my brother. After reviewing all the documents and the finding of how the case came about, he said the city has a major problem in that it all comes down to jurisdiction, both personal and subject matter, which is always open to question and attack at any time. Council said, after reviewing the two city codes of chapters 8 and 31 in the Kansas statutes, that chapter 8 is inapplicable because the structures are already in existence. Chapter 8 covers new development, construction, erection, and building. Procedure under chapter 8 is a preparation of documents as to be for a proposed project and presented it to the city for approval, and that it will meet zoning and building restrictions such as external and internal access, which on approval of the project to proceed, various permits are required and usually involve different contractors. This is not the issue of the case situation, in this case mine. Council said from what I had said and what the documents and the city code and Kansas law revealed, the city is trying to invoke that which is commonly referred to as the conflagration statutes of KSA 12-1750, etc., interpreting City Code 31501, 31502, 31502.1 in a way that statutes were not meant to be used. No jurisdiction. And then he went on to tell me about how these statutes came about. He said that at one time, before these statutes were passed, and usually in a commercial setting, corporations, having moved their operation or having no further use for some of the property, would not maintain the property. But being an asset could keep the taxes paid and properly insured, and if the property caught fire, the corporation would just collect the insurance proceeds and leave the property as it is and not being used in the corporate business, i.e. use the insurance proceeds for some other use, leaving a dangerous and unsafe situation, as the fire usually leaves a building in condition of partial collapse or possible collapse or actual collapse, as conflagration means an extensive fire that destroys a great deal of land or property, is being called consumption by fire, a catastrophic event. In order to curb such a situation, conflagration statutes were passed where insurance companies are required to assess the damage and either have the building raised or repaired and not just settle a claim made by the insured. The point council made to me that the city code provides that some major event occur, such as a fire, earthquake, wind, flood, abandonment, or vandalism, or by any other cause to such extent that the structure is likely to partially or completely collapse in order to come within KSA 12-1750, etc. That is dangerous to life, health, property, or safety of the public or the occupants of the structure. This is the jurisdictional factor in order for a local government unit to act. It is very restrictive in its application. If not, it can easily lead to public corruption, as well as criminal trespass charges, civil rights violations, and intentional torts. Council then asked me if my house was damaged. I said no, as there have been no catastrophic events that have affected my house. I said the facts are the city targeted 20 different houses scattered throughout the city to the same action its resolution imposed on me and my brother, which is demolition. So the city is saying what? The 20 structures were damaged in one conflagration or in 20 separate ones? Neither, as these resolutions are aimed at something different than the intent of the ordinance or statutes involved, as the properties are located in low-rent areas. The inspections used and represented to the council were meant for demolition purposes only, and not any economic feasibility study as to demolition or repair by owners. Case in point, a 6-month-old inspection report dated 9/18/14 on my property was used to obtain council resolution that did not include my garage, but the resolution includes my garage. The end result is that the properties are to be demolished and not a chance of repair. My counsel then told me I needed to file a motion to vacate and set aside, claiming a lack of personal jurisdiction because the journal entry order says your brother was personally served and was not, and lack of subject matter jurisdiction as the order affects both of our legal interests. A motion to vacate was filed and scheduled for a hearing on 10/28/15, which is in 2 days. And I've cited two different cases in State XRL City of Topeka versus City of Topeka. It's a 1992 case that stands for the rule that the failure of the city to comply with requirements of the legislative enactment which gave it the power and authority takes precedence over any ordinance, as the ordinance must fill the purpose contemplated by the legislature, which this does not do in this case. And in another case, William R. Hickman Trust case, the Kansas Supreme Court said the ultimate issue is whether a municipality can force the property owner to make an unwarranted and unnecessary repairs and renovations to such property. In other words, can the city force the owner of either to destroy the property or bring it into code compliance for rehabitable dwelling? Only under very limited conditions, which is considering all relevant factors and not any reputed economic feasibility that would impute non-feasibility of repair. The city's findings of the building official is without facts or law to back it up, as the city's jurisdiction and authority are only as good as the ordinance which it claims under, and where it fails to follow the statutory mandate constitutes an arbitrary and capricious action by an administrative body, and failing to follow the intent of the statute ordinance leaves the city open to a litany of accusations and charges, 2 of which are public corruption, criminal trespass, any of the landowner's property, money or property is taken under these circumstances the city is trying to do. The question now is not how me and my brother proceed, but what authority or jurisdiction does the city have as a right to proceed against our property and money. And a definition for public corruption, I'll let you read that one on your own. So I asked the resolutions be dropped. I'll take care of my property. I have been taking care of it. I don't need the city to try to tell me to demolish it or not. The resolutions initially should have been pulled, and I think on all the properties. I don't know of any floods around here. They haven't had a flood in this town since '51. They did washout foundations at that time. I don't know of any earthquakes. You had any tornadoes here? I don't think so. I don't think you've had anything that would institute the Kansas statutes on a deflagration type of circumstances. So I'm going to wait and move into court on Wednesday afternoon. Hope to see you there.
Okay, thank you.
Anybody got any questions for me? Glad to answer them. My counsel was very, very explicit about this.
Is your counsel present?
I'm sorry?
Is your counsel present?
No.
Oh, I thought you just said he was very...
No, I retained counsel, but they're from out of state. The reason I know so much about this, why you can't do it, we had a big tornado in Washington, Illinois about a year ago. Local authorities could come in and do what you want to do, but not on 20 individual pieces of property scattered throughout the state or the town. That, they said, that's just beyond any kind of jurisdiction or authority or power, you know.
All right. Well, no, I simply asked because you made
And
several...
I think that's pretty
Right.
say about
Well, you had made several references to counsel, and then also several references to your brother. Is your brother... you're not your brother, but is your brother... Does he have counsel, or is he not interested
He's
in...
never been served with anything.
Mayor and Commissioners, Jeffrey Minimum sent a certified letter of providing notice of the order of the building official. It was refused.
Okay.
And not that, meaning that he advised the U.S. Postal Service that he did not want it, not that he just didn't pick it up.
Well, I asked that for, and just as a follow-up, I was reading the judgment from, I don't know what you legal folks call these things, but the document dated July 23rd from the court, the journal entry, I guess it's called, in which
Correct.
part of the whereupons and so on were that defendant Jeffrey Minimum failed to appear personally or through counsel or to otherwise file a responsive pleading as required by law and is therefore in default. So is that...
Well, Mr. Minimum might want to speak to this, but I'll certainly acknowledge that journal entry was submitted on the basis of an affidavit that we had received from the process server indicating that Jeffrey Minimum had been served personally.
Okay.
That was the basis upon which the journal entry was prepared, submitted to the court, and the basis upon which the court...
Okay, so on the 28th then, and I'm just getting to that, on the 28th then, that will be the makeup or the opportunity then for, among other things...
Right, the court will address any of those aspects. It's a regrettable complication, and upon reading Mr. Minimum's motion, we pursued that and learned what had actually occurred.
Right. Okay. Also in this thing, Mr. Minimum said that you represented yourself.
In this case, I think that big of a case. I don't know
Okay.
anything in counsel in Illinois.
Are you your own counsel?
I guess you could say that.
Okay.
Mr. Miniman, who's your brother's counsel?
Hmm?
Who's your brother's counsel? The action that was filed in district court.
I'm
Who
sorry.
filed that? Who filed the action in district court? Last time you were here, you came up and handed out an action that you filed in district court, or indicated there was an action filed in district court here in Saline County. Who filed that action?
We did.
Who's we?
Me and my brother.
Okay.
I mean, we saw the order. It said he wasn't served. I said, just a red flag just went up. I said, this judgment ain't where the paper's written on. It's not.
So he filed on behalf of himself?
You can say file on behalf.
I'm not going to say. I was asking you. Did he file on behalf of himself?
I guess so.
You guess so. Well, there's a
He
signature.
didn't make an entry of appearance, okay?
There's a
That's what you're
signature.
trying for? No entry of appearance.
Okay. There's a signature, and it represented both he and you. I'm just curious who was representing him.
No. He made no entry of appearance, if that's going to be your argument on Wednesday.
I don't have an argument on Wednesday.
I know you don't.
Okay. Well, the questions that I actually have for you are kind of almost moot because I think you've addressed the fact that you didn't think that this structure, there was any validity to the building, our building inspector's claim that this is a dangerous structure. I mean, if
The list I got was 6 months old, and it had different things that could have been addressed by just an ordinance or a nuisance violation. If I didn't correct the nuisances, I could have probably been issued a citation and fine, because you got that grass ordinance that you people go with, and we gotta go out there and mow the grass, and if you don't get up there high enough, you get a citation, and if you don't mow your grass, it's a nuisance. You can be fined here in city court, I guess. But here, that's not what they're asking for. They're asking for demolition based upon nuisances. That's what they said these were, nuisance violations. 6 months old, didn't include my garage.
do you know or have any knowledge of who might have taken down the fence that the city erected to secure
No,
the site?
It's not the safest area in town, so I don't know.
Okay. I mean, because that was part of the. I mean, the reason why we do this, and I say that just the reason why we do these is that to secure a dangerous structure that we don't want anybody to become injured in. So. Okay.
But it has to be dangerous first, and I don't think you found it was dangerous.
Well, and my question for you was going to be, did you feel like you pursued the remedies that were set out for you in this, or do you have any intention whatsoever to cure the dangerous structure? Or I guess at this point it'd be continue the demolition. I mean, where is it now?
That's the question.
It's half taken down. I mean, so if you didn't feel like you had a building that was dangerous, why did you start taking it down yourself?
Because I saw the initial resolution, and I wanted to check it out. And that says what I can do, check it out to see either repair or raise. What the order said, and to diligently pursue it. There's no deadline on how long it takes. It just had a deadline in the statute of when to start, and you put it in there. And it says
Well, but it
diligently
also had language in there that went through the process of having to obtain a permit.
No, it didn't.
To
The
do that.
resolution didn't say that.
It made reference to our code that makes those references. I don't know what the sections and numbers and all that is, but I've read the resolution. And
However, you had to have jurisdiction to begin with to even start the proceedings, and the resolution shouldn't even have been passed. That's one of the big issues, and I think the resolution on all the other properties that you've spotlighted have the same issue if they want to push it. And if I was them, I would push it. I'd push it hard.
Is
'Cause
that
it's
the-
not, you just pick 20 people out to demolish? That's not how the law works.
Well,
what
that's
they tell
actually
me.
that's actually not accurate, because I know I asked recently for a tally of what has happened with several of these properties, and my understanding is that quite a number of them have been or are in the process of being rehabilitated back into use. So it's
They
just
are
not.
being rehabilitated?
Yeah.
Yeah, Mayor, each of those properties would have a dangerous structures inspection checklist. The one for 623 North 13th dated September 18th, 2014. All of those would have those. All of the property owners received notice from Development Services on what they needed to do and the issues with the ordinance. So we can argue about it back and forth. I think a city attorney can address our legal authority.
Right.
Pass.
Okay,
Two
certainly.
questions.
Yes, please.
Mr. Min-
Certain steps weren't taken, and that's one of the big issues you got against you. Very big.
Just two questions, and they don't really necessarily affect the legal action on the 28th, but is it your practice to not attend to your property until you receive a nuisance?
Do what?
Is it your practice to not attend to your property until you receive a nuisance notice?
No. We've been working on it. The interior's being worked on.
Okay, and just,
We've been working on the interior of that house for some time.
and the other question you don't really need to answer, but do you know how neighborhoods become low-rent areas?
How?
Yeah.
Lots of different ways.
Okay, neglect is,
Gangbangers, drug dealers, meth houses.
but do you know why they're attracted to those areas?
Huh?
Do you know why they are attracted to those areas to begin with?
I suppose it's probably the element that lives there.
No, well, neglected properties make fertile
I think it's the
ground.
people that make them that way. It's not just them sitting there being that way. If I understand your question, you just said, oh, if it's a nuisance, why didn't you do something? We were working on the property, have been for the last several years on the interior. Now you make us tear it down? There's nothing wrong with wasn't nothing wrong with the property. Not dangerous anyway. And the dangerous means to the public, to you, to me, to everybody else. And any occupants, there's no occupants in there. So you didn't get your
Can you
facts
pull your
straight.
microphone to, I'm getting signals
sorry.
from the back that
Okay.
they can't hear.
Yeah.
Okay. In front of you, just like this.
How's that?
No, like this.
Okay.
This is, we have these recorded, so we kind of like
I'm
to
glad
be
to hear
able to.
that. I'm glad to
Yeah,
hear
I'm
that.
getting the word that they can't hear you, so if you want to
Oh.
continue to speak, please pull that in front of your mouth.
Can I push this back? I like to lean over the dais.
Okay, well, that's much
How's
better.
that? That better?
That's a lot better. Thank you very much.
All right, you're welcome.
Okay. Well, I think we probably have a disagreement as to what a dangerous structure is, but I can assure you we're going off of what our ordinance states, and our resolutions and our previous actions have been consistent with what our ordinance lays out, and so that's what I'm just saying that's what we base our.
I have to be
judgment
able to do something, and I'm on an injunction, and that injunction's up for the hearing on Thursday.
Well, a lot of this service didn't happen until roughly around July sometime, but
I'm sorry,
but the resolution was passed in May for work to be started May 11th.
Yeah, and it was.
And did you
was.
start that work May 11th?
Hell, yes. Excuse me, sorry.
Did you have part of the thing was get a permit.
Nothing
Get the
was
work
mentioned
underway.
about no permits needed under Chapter 31. My attorney would gladly tell you that. You're talking about Chapter 8. Chapter 8 is development, construction, new construction. That means if I propose to do something, I get plans drawn, I present it to the planning commissioner, to you, for approval. If you approve it as to zoning, height, whatever, entrance, street access, you approve it, then I will need permits. That's construction law, period. You didn't come in on a construction job. You come in on a demolition job under Chapter 31, trying to institute the demolition order under Kansas Statute 1750, et cetera. And there's no jurisdiction because the intent's not there. You got to have a catastrophic event to institute it. Otherwise, it's just taking my money, taking anybody's property or money, and it's confiscation statute. The law's not going to allow you to do that. That's just beyond all belief.
You had the option, though, of construction as well as demolition.
What's that?
You had the choice of construction or demolition
No, I
under
didn't.
that resolution.
No, I had a choice of remedying a situation you people complained about. And the way I did it, there was no set standard as to how to do it. Doesn't say how to rehabilitate a building, doesn't how to say anything about it. Doesn't say how to raise it either. But first of all, it's got to meet the qualifications under the existing law, and you didn't follow those procedures, and that's where the trouble arises. because you're just confiscating property. Taking property, I got to spend money for your benefit, the government's benefit. You take my property for your benefit? That's not how the law works. Right or wrong, Bangston?
Okay. Any further questions for Mr. Miniman? Okay,
I
seeing
do,
none,
if I may, Mayor.
Oh. Okay.
I'm a little bit unsure of the work that was performed by you, and I'm not sure who all might have been involved. Was that to rehabilitate or to demolish?
Is to rehabilitate. No, it was to check out all economic feasibility factors, as which you people should have done to begin with, before you even tried to do what you've done, to see if it was possible. So I'm checking them out to see if I want to go with raising it or reconstructing it, remodeling it.
Okay,
I haven't violated any law. I followed it down. to the
I was
letter.
simply asking, it was a simple question.
Yeah.
Were you demolishing it or rehabilitating it in the work that was performed?
No.
Before the
I
court
was
action?
checking out all the feasibility, economic feasibility factors,
Okay.
which I had a legal right to do, which you should have done when you made the report. And that's what the Kansas Supreme Court has
Mr.
said.
Mr. Miniman, the case you cited tells us exactly the opposite.
What case
It
is
tells
that?
us that we can't substitute, the city cannot substitute that judgment for the owners as to the economic viability of the property. That's the point of that case.
No, you didn't make the feasibility study that imputed either raise it or destroy it. That's what the Kansas Supreme Court said. Better read
Well,
that case closer.
once again, we
Because
disagree.
The only thing,
But
the only way that Hutchins, or that Clay Center case, the only reason the city was able to demolish that property was it wasn't zoned for storage, which that's what the landowner was going to use it for, period.
okay, have you made your determination as to whether to rehabilitate or demolish?
No.
And what are you doing to,
I'm not doing anything now. You got me stopped.
you were stopped only in terms
what?
of performing work without a permit.
I didn't need a permit. It's not a Chapter 8 property. That house was there to begin with. In fact, I think if you read your resolutions and all your statutes, that building's over 40 years old. It's not even subject to anything. Check that out.
So,
too.
so you have not done anything
Not-
since you stopped work
Since I was stopped,
based on the order of the court?
I was stopped. I
Good.
like to obey the law. That's what
That's,
I do.
that's,
You know,
that
somebody-
that order did not stop you from lawfully doing work. In fact, it directed you.
No, it
But,
didn't. It said I had to diligently pursue, and I had to start at a certain time, and it said there's no deadline in the statutes.
Okay.
And I can't diligently pursue something when you've got a court order against me. And I'll tell you something else. I approached one of the people that does this kind of stuff. They wouldn't touch it until this matter's resolved. So tell me I got to get a local contractor when they won't touch it with a court order being involved. They're not going
Okay,
to touch anything.
I
Good.
think that
I
we
appreciate it.
we have our ordinances. We follow our ordinances, and you can. I would suggest maybe next time if you want to play attorney, that you bring your attorney instead of.
I don't need an attorney.
Well,
for-
I think you do. So.
Mr.
Well,
Mayor, may I ask a
I think
procedural
that somebody, if they come out there and come on it, they're going to get hit with criminal trespass.
Okay. Do we have any further questions for Mr. Miniman? Okay. Seeing none, any public comment on this matter at this time? Okay, I see none. I'm going to close the public hearing at this time. Thank you for appearing, and we'll bring it back to the commission for discussion and action.
One procedural question. Is this entered into our minutes as part of the minutes?
Not
I mean,
unless-
if this needs to be referred to later, or should this be? I'm asking.
yeah,
out of
it's
ignorance.
ultimately up to the commission, but I would expect
would
that
you
that
like to
would
have
be
that entered in the record?
something that you would.
Considering the amount of discussion, yes.
Yeah. If anybody would like that, we'll have that done. Okay. Thank you. we're going to move on. So,
Okay.
thank you.
Am I going to get a vote on this right
Mhm.
now?
Well, yeah, but you can go ahead and relax and take your seat. And we'll bring it up here, and I will just say this, that I appreciate the questions and the answer, and I will just make a comment to commissioners that we have a Kansas Open Meetings Act, and so if you're going to say something, say it clearly into the microphone so that we don't run afoul of the Open Meetings Act. So I would appreciate that, and again, thank you for those questions that you posed. So do we have any further questions for staff at this time? Okay, seeing none, I'll entertain a motion.
I move we order staff to proceed with demolition of the structure located at 623 North 13th Street in accordance with resolution numbers 15-7209 and 15-7258, subject to no objections being received by the district court judge at the October 28th, 2015 hearing today.
Mayor and Commissioners, if I may, if the motion is made on the basis that the property owners have failed to diligently prosecute the work directed under the resolution, I think we should include that in the motion as well.
So moved.
Okay. Finding, so moved, being
Yeah.
finding that no diligent
No diligent
prosecution
prosecution of work has occurred
has occurred.
by the
Okay.
owners.
Very good.
Second.
Okay, I have a motion and a second to order staff to proceed with demolition of the structures located at 623 North 13th Street in accordance with resolution numbers 157209 and 157258, determining no deliberative work has been pursued in regard to these resolutions, subject to no objections being received by the district court judge at the October 28, 2015 hearing. Any further discussion? Seeing none, all in favor?
Aye.
Opposed? That passes 5-0. Okay, thank you. We'll move on to the consent agenda, please.
Item 6.1, approve the minutes of October 19, 2015. And item 6.2, authorize an agreement with Rhineco Environmental Services, LLC for the training of staff, packaging, transportation, and disposal of household hazardous waste materials in the amount of $26,109.50 and the 3-year projected total of $78,328.50.
Okay, are there any items any commissioner would like to have removed or amended from the consent agenda?
I'd like to remove the minutes.
Okay,
I'm sorry. Take that back. I had a comment on the agenda.
okay, on 6.2?
No, I'll catch Shandy after the meeting.
Okay.
Sorry.
Okay. Any other? Okay, seeing none, I'll entertain a motion.
Move that we accept the consent agenda as presented.
Second.
Motion is second to accept the consent agenda as presented. All in favor?
Aye.
Opposed? Passes 5-0. Move on to administration.
Item 7.1, resolution number 15-7292, establishing fees in the comprehensive fee schedule for alarm systems designed to summon a fire response.
Okay, Mr. Franz. And Chief Kelsey. And others.
At all.
Committee.
Yeah, my initial's on the blue sheet, so I'll talk about it.
Okay.
The resolution basically provides a fee schedule related to the false alarm ordinance, which was approved by the commission on July 6, 2015. That ordinance provides that the fees should be recommended by the fire chief, and those were attached to your agenda item. There are a few minor changes that I placed at your, I put at your places. Essentially, the changes are limited to reducing the failure to register a fire alarm system from $100 to $50, and then changing the progressive fee schedule to where the first incident of a false alarm is at no charge, and the second incident is at $25 instead of there being two free alarms. Those changes basically bring this schedule into substantial conformity with the police false alarm schedule, which also provides for one free, so to speak, false alarm, and then a graduated scale of fees for subsequent alarms. And if you have any questions about the alarm schedule, we have fire personnel here to handle them,
Okay.
or for me for that matter.
Okay.
But
Questions about the alarm schedule, fee schedule?
I'm not sure who this is for. I'll start with you, Mr. Franz, though.
Sure.
The fee schedule, the purpose of the false alarm portion of that is to reduce the number of false alarms, I would assume.
It is, yes, I believe that would be fair to say, and to ensure that they are responsibly managed.
Would the false alarms then be monitored through the course of the year in conjunction with the fee schedule to know how effective the fee schedule is in preventing false alarms?
I presume so, but I'll defer to the fire
Okay.
department personnel.
All right.
Good afternoon, Mayor, Commissioners. To answer your question, sir, yes, we are in the process of finalizing our database. Once we get the fee structure approved, we'll be opening up on November 1st for registration of those systems. And throughout the course of the year, we'll be continuously monitoring. Ours is a little bit different from the police department in the sense that we're doing ours in-house and not through a third-party contractor. So we'll be able to monitor those a little bit more closely, if you will, with the ability to work with the customer to determine whether it was an act of God, whether it was what we would call a true alarm. For example, if you're cooking and the smoke detector goes off, that's really not a false alarm. We may not have to do anything, but that would be considered a true alarm and not a false alarm. Mm-hmm. The other difference of our ordinance and fee structures, it solely works with commercial businesses, not residential.
That just made me think of a question.
Uh-oh.
So if someone's smoke alarm goes off and they realize that they had left some meat on the stovetop or whatever, and it caused the smoke caused the alarm, the first order of business would be that the person would know exactly why the fire or the smoke is being precipitated, and would not necessarily require a call to the fire department. Are you talking about, are there alarms other than just a residentially installed alarm that would automatically notify the fire department that there's smoke?
Yes, sir. In a commercial application,
In a
not in a
commercial.
residential. Our ordinance, our fee structure has zero bearing on single-family homes. So if you have installed in your home smoke detectors, which I hope you would, if you have a cooking incident and the smoke detectors go off, at that point, we have been called in the past to come out and actually set up ventilation to get the smoke and all of that out of the house. But that is not part of this false alarm ordinance or false alarm fee structure. Mm-hmm. There wouldn't be a set number of 1, 2, 3, 4, and you would be charged with any fines or fees.
There are
we would not be registering those.
There are residences, though, that have monitored fire alarms.
Correct.
As
And-
well.
And if they have a commercial cooking operation, the code does require, if you have a code-required fire alarm system, that cooking suppression system is monitored through the fire alarm system. So if you have a cooking incident, for example, in a commercial restaurant, and you have a flash fire or grease fire in that, the suppression system were to activate, it would also in turn set off an automatic fire alarm, notifying the fire department that we had a fire-related incident at that commercial business. Does that answer your question?
Well, but there are residences that also have
Sure.
smoke monitoring systems that are
Yes.
monitored by a private company
Absolutely.
as well.
Yes, and that is true, but like I say, I just want to make sure that we understand that on a residential application, we will still continue to go like we always have, and there is nothing as far as the number of false alarms any fees or registration or anything tied to the commercial fire alarm side or smoke detection side of the residential occupancies.
Does it,
Solely commercial business.
does the alarm, on the commercial side, does the alarm go directly from the source to dispatch or whatever, or does it go through a third party?
Well, there were some businesses that were monitored through the Salina Police Department. However, effective January 1st, that will no longer happen. And each of those commercial businesses will be required to have their own third-party provider. And so if the fire alarm were to go off in that building, I apologize, if that fire alarm were to go off in that building, then that would go to their third-party provider, and in turn, they would call our 911 dispatch center at the police department, and that is how we would get dispatched.
Okay.
And believe it or not, it sounds like it happens in a very long time, but it happens really,
It's a
really
quick thing, but it'll probably catch a lot of the false alarms.
Absolutely.
That might be towards the type of non-emergency things that tend
Correct.
to
And
happen
they
sometimes.
would then be in communication with their dispatch center or the 911 third-party communication center saying that we had a flash fire on our stove, we got the fire out. However, we would still like the fire department to respond to set up ventilation to get the smoke out, or just to check, make sure there's no hot spots or anything like that.
What is the the one non-charged false alarm thing that we're doing here, the one free? Is that tied to a grace period, or is that just 3 years from now if they have one that's?
It basically, the clock resets annually. Every year they'll have
Okay.
to renew their system, and at that point, the clock starts all over.
You'll get
so
one
if you've
free
had
one
one this year and next year it's time to renew, the clock starts all over. And likewise, if you had two this year, you don't start out next year with two. You start out with 0,
Okay.
and then it's.
So we don't have a grace period. It's just you just get one free.
Well, I don't want to say we don't have a grace period. There will be a 90-day implementation period.
Okay, good.
From November 1st through after the first of the year. And our goal there is to get the registrations in hand, do some more education, do some more training on that. So the customers, I've gotten several calls and concerns about the residential side. That's why I want to make it clear that this in no way, shape, or form has any impact on residential homes at all. But after that 90-day grace period, the expectation would be that they would have that system registered, and January 1, 2016, the clock would start, basically.
Okay.
And we would still, as we've always done in the past, if we have a false alarm, our truck company officers are trained in a manner such that they will determine whether it was a false alarm, true alarm, and if they're not sure if it was a faulty detector as a result of the fire alarm system, they may call us out to do some follow-up and work with the customer to see whether or not it was truly a false alarm, or if it was, believe it or not, a mouse or a bat chewing wiring that was maybe something preventable. So again, it's not just because the ordinance is in place, you have a false alarm. If you go to your second alarm, we'll do everything we can to work through that. Our main goal is to reduce the numbers of false alarms, period.
I keep being confused here. So it's only commercial systems that
Yes.
have to register?
Yes.
Home systems don't have to register?
The only thing that they would need to register would be if you have a burglar alarm system in
Yeah.
your residence,
Yeah.
you would need to register that with the police department. Now, if you have, and I hate to give out a name, let's just say you have ABC Company, and you have a burglar alarm, intrusion alarm that is tied to a smoke detector system, that is totally independent. You won't need to register the smoke or the fire component of your residential alarm with us. Only the police department will be handling the actual burglar component of the alarm system.
Commissioners, it might help to know that the basic difference between why the police alarm program includes residential and fire doesn't, there's a few reasons. One is the pure volume of false alarms related to residential houses that deal with doors being left open and alarms not being reset and so forth. And the other is really, as Roger mentioned, the main purpose for the fire is to make sure those alarms are really working, to eliminate false alarms, but the false alarm is an indication of alarm that's not working properly. So yeah, it might be a false alarm today, but it might not actually set off an alarm when it needs to tomorrow when there's a real situation. And it's very important that those alarm systems work properly. So it's a way to ensure that those alarm systems are maintained properly and work properly, and that's the primary reason. And that their focus there is by far much more on the commercial side versus residential side.
I think the police fine system does allow for not responding automatically after a certain number of false alarms. I forget the category, I'm not phrasing it properly.
And I'll be honest with you, we talked about many variables along the way of it being drafted. I'd have to go back and look at the final version. There's an escalating penalty system in the same way there is here. I don't recall if there was a non-response on that.
Or non-automatic response.
Right, automatic response is correct. Again, if any time someone picks up a phone, they dial 911, they call in, there's the response without question, but an automatic response.
The only thing that our fee structure ordinance would include is after the third false alarm within that 12-month period, if it is recognizes 3 true false alarms, or I take that back, it's the 4th alarm, not the third, it's the 4th alarm. After the 4th false alarm in a calendar period, we would then require the business owner to have a licensed fire alarm company come out, go through the entire system to validate, basically evaluate and validate that system as if it was being installed brand new. And at that point, we would still respond. We would not cut off our response, but that would be a component for them, and that's where there's some fees in there involved with additional fees associated with that process, as far as them having to hire a third party or a fire alarm company contractor to come out and basically recertify that system.
Excellent.
What is the cost for the fire department to respond to a false alarm?
Basically, it's free because it's our tax dollars at work. But when Chief Mulliken gave his original presentation for the actual false alarm ordinance, he used FEMA structure, and it was $350. And I'm just going off the top of my head right now, but it was $350 per person, and then there were some additional fees that went into the different types of equipment that would be responding to those commercial alarms. Some of the things to keep in mind when we respond to a commercial alarm, we're not just sending one truck with 3 or 4 people. We'll send multiple units to that location. I mean, at one point, we could have a ladder truck, 2 engines, an ambulance, a battalion chief, a medical officer. So we're sending a lot of equipment down the road in an emergency fashion, which is not always safe for the community, for something that most of the time when we get there is a completely preventable type situation. And as far as the fees go, like I said, that was back when we originally drafted the ordinance there. Chief Mulliken had that in there that spelled it out. But I do remember that he did use the FEMA table for cost recovery for and it was $350 per person per hour or something like that. Sorry, I didn't bring that with me today.
When we're talking about commercial entities primarily, the fee schedule doesn't seem to reflect very closely the cost to provide that service. The free one I understand, that's a good thing. And the second one's $25. Well, for a company especially, I would think that, well, they might not even be, they may not be persuaded to look into their system at that point. And even after the 4th, it may take the 4th time of you coming out for them to finally say, okay, well, maybe we ought to do something this time. To me, it doesn't seem like the fines are
they're too generous?
I don't know that they're educational. And that's all. And I have a feeling that if a company's system is truly at fault, that the first or the second or the third false alarm won't really get them to do anything besides write you a check.
Sure. I don't disagree with that. Again, our main goal overall, as the city manager said, is to get those systems, get them to where they're continuously being maintained like they're supposed to. As far as the fee structure, it may be a little low on the financial end as far as making them want to do something. But our primary focus is that one-on-one contact with the business owner. It allows us an opportunity to start monitoring these a lot closer and having that additional push, if you will, even though it's a small amount of money, it's still that opportunity to work with them and hopefully get it repaired.
Yeah, Commissioner, we really didn't go into this with the thought that if it's a false alarm, it should totally pay for the response. We really didn't. Really, the issue is that there's of course that initial first forgiveness each year, and then after that there's a financial penalty, and that steps up to the degree that and we'll have to kind of see, but it's to the degree that we think it'll cause them to take care of their alarm system, which is the ultimate goal. Now, at the end of the year, quite honestly, if we find that what you're saying is correct, and in fact we really haven't reduced the number of false alarms, primarily because the penalty isn't sufficient enough, we'll be the first to be back up here and ask for an increase.
See, I think the greater benefit is that every time all these trucks show up, that you'd be embarrassed. If you had a system that wasn't up to par, and you'd want to do something about it. And I don't know, that might be part of the education process too. I would start the education at the beginning.
Right, and we have. We've actually had a class at the Chamber of Commerce Annex where we talked about it was basically a basic fire alarm class and talked about a lot of those components. And once we get the ordinance completely finished before we put it live on the city's website as far as registration, we'd like to, again, have some more education out there, kind of a question and answer type situation to clarify any concerns or any issues before we actually implement it in 1st of January.
Okay.
Any other questions?
Nope.
Mr. Chief Kelsey, I do want to say one other thing, that I understand your fee structure and the cost, and like Jason said, that we didn't go into this looking to subsidize. We just wanted to make sure that we brought the systems up to be monitored and properly taken care of. And so that's why we tried to correlate also with the police department on their fee structure as close as we could. It was another reason why we brought that. The third thing is although we do have a false alarm, in that we will send out the inspectors to try to assist the owner of that structure to prevent that at a later date. We will follow up with our inspectors to help prevent that second, third, and fourth alarm.
Yeah.
Right. Well, and I think for the fee, for the number of the fee, I'd hate to get that fee too high to have people kind of lower their standards for emergency. And so it still would be nice if they erred on the side of safety versus economics.
Absolutely.
So, yeah. And that because that is the key, and the key is to bring awareness and bring the number of those calls down, because we're not going to eliminate them, but bring them down.
Yeah, and we know this is new, and that's part of it too. We want to jump in. It needs to be done. And again, it goes back to, it's not so much just the pure nuisance of a false alarm. That's a problem. It's a cost. But it's the fact that when we have dispatched, whether it's police or fire personnel, to a false alarm, they're then out of position for a real alarm. Right. And so you reduce the number of times we're out of position for a real alarm, and that makes our response time better. Because what happens is if one unit is out of position, they may be too far away to respond from the false alarm location, and you may have to take another unit, but you will have an effect on your response times. Right. So this should help with that. Right. We have good response times, but I think we can make them even better.
Yeah. Great. Okay, thank you. Any more questions?
Just one, not to stretch this out too far. What's the remedy if the business owner refuses to have an outside alarm inspector come in, and after that fourth false alarm?
There is, I believe, part of the ordinance will address as to, we had the authority to pull their fee or their licensing for that structure until they can bring the alarm within ordinance.
That would work.
Yeah, they would have the option of a fire watch, but that's pretty expensive to have a trained person there, possibly 24 hours a day, or at least a good part of the day. So it wouldn't take too many days of that for them to realize that staying in business and getting their alarm fixed is a good thing.
Mm-hmm.
Thank you.
That's a good question. Okay, do we have any public comment at this time? Okay, we see now. We'll bring it up for action.
Thank you.
Thanks.
The mayor move approval of resolution number 15-7271, establishing fees related to false fire alarms. With
Second.
the corrections or Well, these actually, the corrections were in this. That was just for our
Yeah.
notice, okay.
Second.
Okay, I have a motion and second to approve resolution number 15-7292. Any further discussion? Seeing none, all in favor?
Aye.
Opposed? Carries 5-0. If I can just ask real quick, Mr. Scragg, is there another item that we might be considering before we get through with administration at all? You had
Yes.
mentioned a letter to me from a resident.
Our intention is to suggest that we cover that in the executive session at the end.
Okay, so we'll add an executive
Yes.
session? Okay. Okay, thank you.
Item 7.2, resolution number 15-7293, authorizing the mayor to execute a compliance agreement with Michael Carter, providing for an extension of time to repair or remove the designated dangerous structure located at 910 North 11th Street.
Okay, is this a Mike Scragg or is this a Jim Brown? Or is this a both?
If Jim's willing to start, I'll help out where needed.
Okay, leadoff pitcher, reliever. Let's go.
Thank you, Mayor, Commissioners. We're bringing forward to you this afternoon resolution number 15-7293, and this is to authorize the mayor to execute a compliance agreement with Mr. Michael Carter, providing for an extension of time to repair or move a dangerous structure located at 910 North 11th Street. We have a timeline of events there that brings us up to this current date. And since the last inspection we had, which was on September 11th, it appears some repairs have been made or have been started, and that is per the attached report that you have that was provided by Mr. Carter, dated 10/19. As directed by the City Commission, October 19th, we have prepared a compliance agreement to extend this completion date as set initially in Resolution 15-7214, and to reflect the completion date of December 27th, 2015, to coincide with the compliance agreement. And it also requires the owner to reimburse the city for administrative costs to date, and a deposit of financial guarantee, whether it be cash or a letter of credit, whatever it may be, with the city to cover any of the city's demolition costs if the owner fails to perform as agreed. And again, we have our recommendations and we have our cost included in that to reflect those. It's going to be reflected also in the compliance agreement. It was also brought to my attention, well, not brought to my attention, but on Friday, last Friday, there was a meeting, a subsequent meeting with Mr. Carter, I believe Mr. Craig, Mr. Hobby, and I was unable to attend that meeting, whereas I was detained with another meeting, and they probably have additional information. And it was also brought to my attention this afternoon that Mr. Carter may be here to speak on the financial portion of this as well, and maybe modify. Not unsure on that one as to why he may modify. But he is here in attendance to address the commission.
Okay.
And if I may, I'll take the handoff from there. Mr. Brown's correct. We met with Mr. Carter and discussed what he's done so far, what he intends to do in terms of the work, and I think the terms of the compliance agreement reflect that. There was discussion about the total value of the financial security as well as options to either just deposit those funds and we would hold them in escrow, or to provide a letter of credit. And then the one other thing that I would tell you is this property has yet to be contracted for demolition. At the initial outset, which was April 27th, we were aware of Mr. Carter's intentions to do renovation work, and so the deadline was set for October 11th. So we've got 5 properties that have missed their deadline and we proceeded into the process to the point of awarding a demolition contract. This is not one of those, which is one less complicator as far as extending the deadline. But for the most part, I think our conversation, we agreed on an approach, we agreed on a timeline, and I'll defer to Mr. Carter to speak to the financial security or any other concerns he might have with the compliance agreement.
Okay, any questions for staff at this time? Okay, well, we'll be happy to hear from Mr. Carter right now then. Hello.
I guess on Friday I did have a meeting with these gentlemen, and we decided that we were going to take one aspect of this out, which was performing the work to a point where there was an occupancy permit issued. And what the thought was is we'd go ahead and get the safety issues corrected immediately, and then they'd sign off on it, and I'd spend the winter in the house fixing it up. The deal is, I bought this house to fix up. It's on the north side of town. I'm willing to invest my own money. I'm not going to the bank asking for money. I'm 2 days late on asking for an extension because I wrote the wrong date down. I believe we have corrected the safety issues. We replaced the decking on the back that was bad. The porch is gone. The sill plate is fixed. I'm missing a piece of siding. That's about it as far as safety goes. I went to the bank this morning and asked them for a letter of credit for $10,000. I'm in the process of buying a business in Alaska, and they told me no. As far as putting up $10,000, I have the money, but if I put the $10,000 up, I'm not going to have the money to fix the house. So that's my dilemma. All I'm asking for is 2 months to get this thing to where it's got brand new siding on it, the house looks nice, and there's no safety issues. The second issue is I'm a licensed contractor here in Salina and have been for over 20 years. I do heating and air conditioning and also remodeling. So this is not like I'm having to go out and hire all this work to be done. I have the capacity and the capability to do it myself. So I guess where we're at is if it's a matter of me having to come up with $10,000 or you guys tearing it down, I guess you're going to tear it down.
Okay.
So.
Questions, Mr. Carter? Just a couple quick ones because
Sure.
Mr. Sprague mentioned basically 3 legs to this deal with you: the approach, the time, and the cost.
Mhm.
And it sounds like the approach that you've worked out, and any one of you can correct us or let us know, correct me, let us know, is that it sounds like your approach is get the safety things taken care of first, get those signed off on. What is the time frame of that happening?
Easily within 2 months. If
Yeah,
I could have started it last week after the meeting, I'd probably have the siding on most of the house already.
The compliance agreement set a deadline in December 27th.
Right, and that's
2
plenty
months.
of time.
To complete that portion of it.
The biggest
Okay.
issue I had initially was trying to find a contractor here in town that would pull a license for the addition of that. I couldn't find anybody that would do the work
Okay.
or had time to do it.
And so, so there's no issue with the permit being pulled? We got the permit pulled? I mean,
No.
that's taken care
Not
of?
yet, no, he would do that if
I
we
don't
can get
pull
the deadline
permit.
extended.
Okay.
The contractor I hire will pull the permit. I will pull the
Okay.
permit for heating and air and gas lines and other issues. in the
But we're
house.
not going to have any issue, I mean, I'm just saying the way is clear for that.
Correct.
Okay. So that takes care of the approach and time as far as where I am. There's no contract for demolition on this thing, so when's the next likely, I mean, we did have a motion to where we can now do demolition on a case-by-case basis, correct?
That is correct, and the contractor was in the office today signing those documents, so he is ready to go, as we have others potentially that are in the waitings to complete one. We had one that actually, the resolution expired as of today. Inspections were made, there was no progress being made, so we've already have one that could potentially be on the
Okay.
project. So yes, we do have a
So
contractor.
we're not in this situation now where we're saying, okay, let's wait and get enough of these put together to put out a contract. We're now to where if December 27th rolls around, and things aren't checked off
Correct.
sufficiently, then we can take action at that point.
Correct, yes, sir.
Okay.
Could I clarify one thing on the date? December 27th is for a certificate of occupancy or for just the safety
No, that's for the
issues?
safety issues and
Right.
the blight to the house.
'Cause I thought I heard certificate of occupancy earlier.
He mentioned, that was the original conversation, and
Right.
Friday we talked about dividing up that work such that the exterior was resolved, the safety issues were resolved, and then he'd have the normal time frame of a building permit to complete the
Yeah,
interior.
a normal time frame on a building permit is about 6 months once the permit's pulled. And I don't plan on pulling the heating and air permit and everything all at once. It'd be done in
But
stages.
right, and our main concern is that it get taken off the dangerous structures.
And it's not
Part, so,
dangerous at this
okay.
point.
Okay. Well, to fulfill the requirements to get it off of the
Off
list
of this,
and so on.
basically, is to get either paint on it or some siding, but I'm gonna side the house.
Okay, any further questions?
No, sounds good
Okay.
to me.
Thank you.
Thank you.
Okay, do we have any public comment at this time on this item? Okay, seeing none, bring it back for any further discussion. Do you have a comment?
Yes, if I may, I think it would be helpful to call on Aaron Martin in response to the conversation we had. There were some changes made to the documents, and just want to walk you through
to the compliance
what the current.
agreement?
Yes,
Okay.
the resolution and the compliance agreement.
Okay, good. We'll do that and
And then
make note.
it might also be helpful to discuss, if you are inclined to remove the financial security, what that amendment might look like.
Okay.
Good afternoon, Mayor and Commissioners. Really briefly, Mr. Scragg mentioned some last-minute changes to the documents that you've been provided. The compliance agreement, after conferring with Mr. Scragg, we have actually not changed that from the one that you've been provided with. What we were conferring about is it does reference a $9,000 financial guarantee in the form of cash or certified funds, and we were discussing the potential need to change that depending on the terms of the ultimate agreement that's approved, if at all, today. The second item that was changed was the resolution that was sent out in the packet last week. City Clerk is circulating copies of a revised draft, and a few changes were made to that simply to address the contractual nature of what we're doing here today. We're approving a compliance agreement which has the effect of extending the compliance agreement deadlines established by your previous resolutions. The resolution that went out in the packet, after looking at it further, we thought there would be some value in addressing the contractual aspect of what we're doing here today, while at the same time reaffirming the validity of everything we've done leading up to this point. So if a compliance agreement is approved today, we would recommend that form that you've now been provided and substituted. And the compliance agreement may need changes depending on where you wish to go with that. Thank you.
Okay. Thank you. I have a quick question on the, this might be for Mike. On the financial guarantee portion, you have an A and a B.
Correct.
And the A looks like it's to cover administrative and
Yeah,
various other-
those are intended to be the costs we've incurred so far.
Right, and then the other one is a
Right. The
forward-looking.
B is looking forward to
the 9,000. The big
potential
bulk of it
cost.
is the. Okay.
And then while we're on the topic, then additionally in section 4, city remedies, that is a discussion of authority to proceed with demolition as well as use of those funds. So if the financial security were to be removed, I think section B would be struck, and then I'm going to need help from legal counsel in terms of how to reword section 4 to reflect that approach. And it may be as simple as striking subpoint 2 in section 4.
That would appear to be the case. I'm looking at Mr. Martin to be sure, but, oh. Three B in its entirety, and sub 2 under 4. Mayor and Commissioners, that the elimination of that aspect would appear to be able to be achieved by the deletion of paragraph 3B, as you suggested, Mayor. And then under 4, subpoint 2, regarding liquidation of owner's financial security, the deletion of that subpoint 2 would address that step.
I'm sorry, Mr. Beck, could you repeat just that last item that you mentioned?
If you look at section 4, subpoint 2, under 4,
okay.
that is the step that would be involved if that financial security was in place.
Okay.
And if there was a failure to perform. If it is your choice not to make that requirement, then simply eliminating 2 and making present number 3 instead 2 should accomplish that, if that is your wish.
Okay,
Yeah, yeah. The question was, and I'm glad you presented the answer that way, because it was to say, if it's doable with Mr. Carter, would it be possible to do A and not B?
Yes.
Because if
Certainly.
if he hasn't got the financial ability to do the 10,000, my question would be, is the ability there to do the 1,049.42? And so that seems a lot more doable than.
Procedurally, it's possible. I'll defer to Mr. Carter to.
Okay. Yeah. Have you back up? Do you understand that?
Yeah, I
Okay.
can write him a check tomorrow for the $1,000.
Okay.
Take care of that.
Seems like a good thing to me.
And
Okay.
in section 4, again, December 27th, is this into full city code compliance or just enough to remove this from the dangerous structure list?
The code compliant items that are cited in Exhibit A are limited to the exterior work, so the intention would be that it resolves the items itemized in the exhibit.
Okay, thank you.
Right. Okay, further discussion, motion. Whoever wants to jump in first can go. Oh, did I ask for other public comment yet? If I didn't, I'm asking now, and if we don't have it, we'll move on. So now we'll take a motion.
Mine's on the same block.
Well, we're going to get to yours next. So, okay.
I move that we approve resolution number 15-7293 with a change to the compliance agreement to delete paragraph 3 under payment of city's cost financial guarantee, paragraph B, and under paragraph number 4, city's remedies, to eliminate item number 2, liquidate owner's financial security obligation.
Second. I'm sorry.
Yeah, I was going to finish that. Authorizing the mayor to execute a compliance agreement with Michael Carter, providing for an extension of time to repair or remove the designated dangerous structure located at 910 North 11th Street.
Does the date December 27th need to be included?
I think that's in the agreement.
That's in there.
It's in the agreement.
That's in
okay.
the resolution, yeah.
Okay. Second.
Okay, I have a motion and a second to approve resolution number 15-7293 with changes as stated to the compliance agreement for the repair and removal of designated dangerous structure located at 910 North 11th Street. Any further discussion on that? One quick question for staff. Just as a get my brain around this, this compliance agreement is with Michael Carter.
Correct. Michael Carter is the owner of the property.
Right. Okay. Okay. Very good. So, and I take it that there is a relation. So, okay. So the thing about the $1,000 being good is, okay.
Take care of that.
Okay. Just as long as it's not a surprise to Michael. So, okay. Very good. Okay. All in favor?
Aye.
Aye. Opposed? That passes 5-0. So, thanks and good luck, and appreciate your willingness to get that taken care of. Okay, our added item.
Item 7.3, consider an extension to resolution number 15-7213 in reference to the dangerous structure located at 906 North 11th Street.
Okay. Is this going to be Mike Sprague handing off to Jim Brown, or is this going to be the other way?
This is going to be Mike Sprague winging it a little bit.
Okay.
As you may recall, we identified 20 properties, and the questions come up a couple of times how those properties were identified. We reviewed water billing records and identified properties that had an extended amount of time without any water consumption as a starting point of abandoned properties. And so then we followed up on those, and that's how the 20 that were identified came up. So as you recall, back in April of this year, we passed resolutions related to dangerous structures. 4 of those approached you about an extension, actually 5 of those, and 1 of them got 2 extensions. So the timelines all started together, but they started to splinter. And even on the April 27th action, different deadlines were set based on comments that were made that night and based on conversations that had been had with the building official about renovation work that was going to be done. So now as we approach the end of those deadlines, we're following up on them. 5 of those properties missed their deadline, and on August 17th of this year, you authorized awarding demolition contracts for those 5. Mr. Meinhardt's property at 906 North 11th is one of those for which the contract has been awarded. He then recently approached staff about the possibility of an extension. In fact, we thought he was going to be here last week. He's here this evening wanting to make that request. Very similar to Mr. Carter's, the process we went through with Mr. Carter last week. First step would be to hear him out, for you to then make a determination whether you wish to ask staff to proceed with some additional action. But I would note that there is a distinction that we may need to discuss in greater detail related to the fact that we're already under contract with a contractor to demolish the structure. So with that, I'd be happy to answer any questions. I'm sure Mr. Meinhardt wishes to address you and talk about his specific situation and his intentions.
Okay. Any questions for staff at this time? Just one quick one before we get going here. What is the date of that scheduled for that demolition to commence?
I'll defer to Mr. Hobby to answer that.
We have been working with the contractor. We received approval today, so we are ready to proceed at any time. There'll be 2 other houses in front of this one, so we have 2 weeks, maybe 3, before it'll be ready to demolish.
Okay. Good. I'd hate to see that whatever the decision is, we wake up tomorrow morning and it's down. And we do have, obviously there are bids on this thing, and are there breach of contract damages for pulling one out of 5 out of this? Or
Yeah, just to clarify, not only are there bids, there's a contract been awarded beyond the bidding stage. And I should have clarified as well. You mentioned earlier that the 5 that I've described are under specific contract. Then we also, after that, entered into a contract on a square footage basis. So rather than on an address by address basis, we can be more responsive going forward. So the property in question the contract was awarded, it was address specific, and with respect to breach of contract, I'll defer to legal counsel to address that.
Mayor, if I may, I've got one quick question for Mr. Sprague. Mike, when you compared the property with the Carter property, can you kind of highlight the differences or similarities with regard to any work being completed to date?
The primary distinction is the Carter property had a deadline of October 11th, which just shortly passed, while the 906 North 11th property had a June 11th deadline. And given those deadlines, that's why we're further along in the process of declaring it dangerous, awarding the demolition contract, and that's why we're under contract for 906 North 11th, where we're not for Mr. Carter's property yet.
Right, and just to follow up on that, did Mr. Carter not give some indication at the onset of this process of his intent to
He did.
renovate? Okay,
Right.
and then I did notice in that package with the photographs that there was a few things done. It looks
Correct. Within I'm not sure the time frame, but in the very recent passed, there's been some work done.
Okay.
But, yeah, I think one of the distinctions is Mr. Carter was in contact with staff a couple days after the deadline passed, and so we were just on the verge of getting started in the next step in the process.
Okay. What was the date for the final completion on this one? I got the date August 17th, but that's when we let the contract.
Right. It was actually Resolution 157213 passed on April 27th with a deadline of June 11th.
June 11th. Okay, it was one of the original. Okay. Okay. Well, right now, then, we'll go ahead and hear from Mr. Meinhardt. Thanks for being here.
First off, I'd just like to apologize for letting the place become such an eyesore. I don't know, my dad passed away back in '09, left me a big chunk of cash, and I've been pretty much high since. I've got 38 days sober now. I'm doing the drug court thing and whatnot, and I don't know. I hired Christy Kopis about a month or two ago, to, Riddle Management, to get it all going and get it done. I gave her a check for $3,000, and she came down to get a building permit and made it sound like you guys ambushed her or something. And I don't know, I thought they were cooking dope or something in there, but to my knowledge, that's never happened or anything like that. And I'd just like to ask for another 30 days to get the utilities and whatnot hooked up at least.
Okay.
Then I can go in there and get to work on it.
So it sounds like you have met with staff
Yes.
on one.
If I may interject, sir, yes, Mr. Meinhardt has been in and talked to staff on a couple occasions here the last week to 10 days about his project. We explained to him at that time we'd already had it contracted for demolition, and Christy Kopis also was explaining the same thing. The terms that Christy understood was the fact that it had already gone to bid for demolition, and we had awarded that contract for demolition, and it would be very tough to stop that process unless they came to talk to you, city commissioners, into extending that process. The contract we have for this house is $6,200, and city staff also has some stranded costs as well with the process of, as you know, our notifications, legal fees, and those type of things that we have completed, very similar to what you just went through with Mr. Carter on his process. The contractor has been requested to give us a cost estimate of what he would take to buy out his contract. As Mr. Sprague has mentioned, there are several stranded costs that the contractor has already entailed on this project. He told us that $5,500 would be his minimum cost to buy himself out of that contract.
So it'd be $5,500 plus our stranded costs, which
That would be correct.
roughly $1,050 if it's similar to. Okay. Okay. Questions for staff or Mr. Meinhardt?
I guess I just want to, what is your ultimate plan for the property?
To have it a rental, I was probably going to hire a different property management place. She offered me $2,000 for it, and I just felt like she was trying to steal it out from under me pretty much, I guess. I thought her husband was a building inspector when I hired her. And come to find out that's not the case, so that's the main reason I hired her, just to get this walk through.
Would you be able to, if we're looking at this with staff, if we're looking at sort of the same process we're looking at last week when we went through this, what we did, and just for your benefit, is that we basically instructed staff to work on what we just passed was a compliance agreement.
If you guys don't want to do it, I've had a couple people offer to buy it, and I can sell it to them. Kevin Christensen is one of them. He's probably the one I'd have on the license doing the work anyway. So
Okay,
I'd
well-
rather have $5,000 out of it than 06 for having it bulldozed, you know.
Yeah, I think, and you guys help me out, Mike. I think at least what I'm looking at here is we have to do it or it's going to cost us $5,500 minimum, plus $1,050 stranded cost that we have in the deal. That's $6,550, okay? I would say right now, that's the value of what we need to do, we would need to see in order to stop the deal. So however that works with who you're selling it to, the
Pretty
problem
expensive bid.
the problem that you have in selling it to somebody is that they're buying that $6,550 bill. Okay? So I'd love to have you work with staff somehow, but that's kind of where I see the rubber hitting the road, what that looks like. So I don't know if that's something that,
Everybody I took through there said they've seen a lot worse and stuff,
Yeah.
so if you want me to sell it to somebody else, I'll be happy to do so.
yeah, well, if it's,
The difficulty with selling it to someone else is there's a code obligation to disclose the current citations against the property
right,
for the purpose of them picking up where you left off in terms of responsibility for the violations. So it would not be a clean slate. It wouldn't restart the clock. They would be assuming the
right, they'd be buying,
obligations.
at the minimum, they'd be buying that $6,500 bill
That's
for,
the demo, that's to have it demolished, so not to, what would I'm not gonna owe 6,500 just to,
well, but
just
in,
to start working on it.
but in
am I?
order to stop a demolition on that, there would need to be some sort of financial guarantee that says time out, and that's what that 65 is for. It's not to, at that point, it's not to pay for the demolition, it's to cover the security in case there is not a compliance agreement in place and the work being done prior to the need to demolish it.
Just sounds like I'm still having to pay for the demo just to have it not done to me.
Well,
Well, what it is paying for, it's basically paying the demolition
I got no
contractor.
problem paying a couple grand for the bids and the times wasted on it, but I do have a problem paying for the demolition of something that's not even gonna be taken down or done anything with.
Now,
It's a deposit, it's basically a deposit, Commissioner.
And it was not
Well,
demolished,
it's,
you would get that
oh, I'm sorry.
5,000 back.
No, basically, you're paying the demolition contractor to not tear it down.
Right, we've already awarded the contract to the demolition contractor based on the missed deadline and based on the prior process. So we have a contract with that contractor. Whether we wish to tell them not to proceed with demolition does not relieve us from the financial side of that contract.
Right.
did he have a detailed list of expenses that he's incurred related to this property that would add up to that $5,500?
Commissioner, Mayor and Commissioner, if I may, I think we are getting into an area that does involve a contractual relationship between the city and the demolition contractor that I do think any discussion of that contractual relationship warrants an executive session discussion rather than either Mr. Scragg or me or anyone trying to speak to that.
Okay. So that would be the details of
Publicly.
that contract.
Well, there either has to be some negotiated resolution of that,
Right.
or the city, I assume the city does not want to find itself in a default scenario under that contract.
Right.
And so far, anything that I've heard suggested by the owner puts us in that position, so.
So then he would be paying to not have it torn down, just for
At this point.
clarity.
At this point, it would be. Is that,
I'm
is
paying
that
for
clear
a
with you?
demolition so it won't happen.
Right.
Right.
All right, I'll put a flagpole in instead.
Yeah. Well, the action we're here to take today is to determine with you whether you want to move forward with staff on trying to work anything out on this thing. Are you,
I'd rather put up a Morton building and hide my toys there. I don't know. The neighbor runs the Wild Wild West, so she could probably bring me home some strays too. I don't know.
well, the problem with using the property for something else is that eventually you're going to have to pay for it because the demolition costs will be assessed to the property, and within a 3-year period, I believe, that's going to have to be paid for before you can do anything else with it.
I can pay for it right now. I just don't want to. I'd rather have something I can charge $500 a month for.
Yeah. Okay, well, what do we, any further questions?
I just remember, I'm kind of disappointed because I kind of remember when you were here with a friend of yours, and you went out quite happy that you were going to start right away to work on that house. And so I'm kind of disappointed in that. And I'm hoping you'll work out some kind of an agreement with Mr. Scragg, some sort of a compliance agreement.
I'm just waiting to see if I can do anything at all with it. That's why I'm here.
It wasn't in
I tried getting that, so I hired Christy Copus at Rental Management and thought her husband was a building inspector and paid her $3,000 to get something done on it and not have to be here today, but that obviously didn't happen, so here I am.
Do you have an estimate about how much the property is worth today?
I would, right now in current condition, probably 10,000 with 5,000 in it, it's probably worth 30.
We don't have the slide from the
That was the plan.
before
so.
probably, on short notice.
A little bit of time I could find it. But I would agree, it's not in horrible shape. I mean, I agree with Commissioner Crawford. There was an opportunity to fix it up, and unfortunately, we missed the deadline. We proceeded to the next step, and we're under contract at this point. It's not.
Was the question you were getting at, Commissioner, was it, how much does he feel he could get out of the property if he had to sell it?
Right.
And would that cover
The cost
the
of-
buyer paying the demolition contractor not to tear it down and still allow him to,
be okay.
Mr. Meinhardt to be okay, the person buying it to be okay? I think where we are, just in a nutshell, someone correct me, but where we are on this thing right now is, looks like the minimum of stopping the demolition is about 65 something, 65.
I thought that
and
was the
change.
cost of the demolition.
Right. And since the contract was,
So I got to pay
we
that
did the
just to have
contract in
nothing
August,
done?
a couple months ago, a little over 2.5 months ago.
I might tell you that the Salina Police Department stole my car from me. It was the Mustang leading the parade. So I got a lot of hate for me already, or a lot of hate for powers that be in this town. I don't know.
Yeah, I'm not familiar with that, and
I kind of want to fight, really, so I want to
Yeah.
bulldoze it.
well,
Aren't you kind of trying to get your life together, though, a little bit?
Mm-hmm.
Yeah, that's what I thought. Was this your family's house?
It was my dad's, yeah, left me in the estate.
Dad's house?
And I just let it go ever since he died, pretty much. I've never had a tenant in there or anything. 38 days today off dope, so I went and hired Christy after about a week sober, and
Well, I think I'd get my money back from Christy if I were you.
oh yeah, $3,000 to get the lawn mowed.
well, our determination up here is to send it to staff to work with, but I'm not hearing from you that that you've got desire to work out with staff. Any
Oh,
sort
yeah,
of financial?
I'd like to get it all stopped. I don't want to pay $6,000 just to have nothing done.
Is there any remedy that is shy of the $6,000 that's at all possible?
I don't know,
Is this in the
Commissioners, but-
revitalization area or anything?
It may be, I don't know. Gary can answer that.
I really wouldn't want to get into any contract negotiations with the demolition contractor who's not here to do that with us. So I would hate to say that we could reduce the cost or add to those costs one way or the other. And
If it is, and if they're allowed to do the project and whatever value it is, they could come and fill out the paperwork and that whatever. But the real issue is that, as you know, and it's unfortunate, but the time to ask for an extension is not after we have a binding legal contract with a demolition contractor. That's the problem, because we have that, and as Greg mentioned, that's binding unless the demolition contractor would say, "Hey, no problem, I'll let you out of it." So that's there's other aspects of that, and we can talk about in executive session if necessary. So that's why there's a situation to where there's in essence a cost to pay not to demolish it. Not sure exactly what that cost would be, but there's likely a cost to pay. Then in addition, you have a situation in which you would likely, we're presuming, and you may or may not, want some form of a financial security to make sure that if the structure survived demolition, that it's actually going to get worked on. And what did we recommend until we saw with the last property, 25%?
Right, 125% of the demolition cost.
Okay, of the demolition cost. Okay, so 125%. Because if the work doesn't get done, then you have a deadline, and then the house will get demolished at that point, no matter what, with those dollars. So you're talking about roughly a little kind of double, close to double of dollars, partially to make sure that we deal with the demolition contractor, and then partially dollars that would go back, presumably if the work's done, go back to the owner. But just that's the deposit piece. But initially, you're probably looking at, I'm going to just throw it out roughly, $12,000 to $13,000, possibly just to save the structure and then make sure it gets fixed, or we go in and fix it with half of that. Or I say we go in and fix it, we go in and demolish it at that point, and depending on what work's been done or not done.
Well, would there be any value in saying, and I don't think we voted on it last time, I think it was just a consensus of saying, yeah, we'd like to instruct staff to work with the property owner. Is there any value in saying that? And if there's something that happens in the next 24 hours that you can work something out, we can have an action on our.
I got to go check into CKF till Wednesday.
Well, I
Judge
just
told me
mean,
earlier, I don't know.
but between now and the time that we think that maybe the demolition
me
is
there.
going to take place, that
'Cause I had whiskey with my
That-
bloody steak yesterday. I don't know.
that we
Long
can.
story.
Is there any, just to say, if something is worked out, it can come back to us? If Mr. Meinhardt decides that.
What would be
just
the
wants to let
deadline
it
of,
drop,
assuming that the demolition contractor is satisfied with whatever resolution, Gary, what's kind of the drop dead date of Monday, the drop dead Monday of coming back?
No later than 2 weeks.
Okay.
So, I mean, we're in that second meeting in November at the latest. Contractors got 2 to 3 weeks of work lined up, so.
And so in that case, so no later than 2 weeks, and we'd recommend a deposit of 125% of the demolition. You'd get to decide if you want to apply that or not, plus whatever dollars that it takes up to the contract amount to address the demolition contractor's need, because we're under contract.
Okay.
So it's going to be more than a couple, three. I mean, it's going to be pretty significant wherever it falls, at least as what needs to be put down early. Some of it would, if the work's done, like I said, the deposit would go back eventually, this financial security if the work's done, but anything related to the demolition contractor would not.
Right. So what we can do is we always welcome staff to work with you on
I'll
that.
probably just sell it to my buddy Kevin Christensen and let his attorney deal with all them, I don't know, headache.
Okay. Well, we'll go ahead and we can hear public comment, or.
Sure.
Yeah, we can hear public comment, and then if we kind of want to hear all this and then give staff a recommendation of one way or another, we'll do that. Okay, thank you.
Yep.
Okay, no public comment? Bring it back up, and my feeling is just sometimes it's tough to make decisions like this in this environment, and sometimes it's easier to work with staff and come up with other areas. So I'd be welcome to suggesting that staff, if Mr. Meinhardt wants to come in and try and work on something, that if there's, if the thing is that can't put anything down, can't do anything, then we take formal action at that time on.
Yeah, I think one thing that'd be helpful to know, commissioners, if you feel like you can give us just your general thoughts, is that if whatever we can work out with the demolition contractor, if anything, is it, first of all, is it your desire to save the structure? And if it is, would you have an expectation of a financial security in the amount of 125%? Because otherwise, if we don't know that, we're working off a pretty big palette here, and we don't know what colors we have. But if we know that, it kind of helps us understand the picture. So you would...
that's acceptable with me. I don't...
Yeah.
Okay, so we kind of know we know that we're looking at a financial security of 125%, presumably. At least that's what we'd present to you, and then we can figure out what our options are with the contractor and the contract.
Well, and I prefer to have something and take formal action on it since Mr. Meinhardt took time to come down here today to.
Yeah, we can do that now. If there's no other option, it's set to go. But if we can come up with something that works for Mr. Meinhardt, we'll bring it back to you.
Right, appreciate that. Okay. Yeah, 200. Mike, your office, 200? He'll
Yes,
take it.
uh-huh.
Thank you.
Yes.
Okay. Everybody good, or Vice Mayor, you okay on time? You got a...
Yeah, I'm all right.
Okay.
Yeah.
Nobody needs a break. Okay, that's all I was getting at.
Was that a question?
Was that a question?
Was that an offer?
I'll let you know.
Well, usually we get to about this point and all of us are...
I would appreciate a 3.5-minute break.
Okay.
See, it's not always.
Take
me.
3.5, we'll take 3.5 minutes to use the facility, so, yes, thanks. Thank you, Mike. I figured that's what it was. Good deal, way to go.
What? Oh, there it is. Is that around my remark about the open meeting violation?
Okay, we're back on, and we're moving on to development business.
Item 8.1, land use matters relating to the west side of South Ohio Street, north and south of the Ohio Midway intersection. 8.1A, first reading, ordinance number 15-10809, amending the future land use map of the Salina, Kansas Comprehensive Plan to change the future land use of designation of the west side of South Ohio Street, north and south of the Ohio Midway intersection from future urban residential to future public, semi-public. 8.1B, first reading ordinance number 15-10810, requesting approval of zoning change from R2 district to a PDD plan development district and the approval of a preliminary site development plan for proposed entryway improvements for the Bicentennial Center, including an electronic message center sign to be located at the southwest corner of South Ohio and the Midway.
All those in favor? Kidding. Okay, up to bat and on deck is Dean Andrew.
Well, we will burden you with a staff report on these two items, but the first item is a consideration of what the future land use map and the comprehensive plan should say about the South Ohio Midway intersection. And as you know, the plan was adopted in 2010. At that time, there wasn't a great deal of discussion about the Bicentennial Center or extending Kenwood Park out in this particular location. And so the land use map that was adopted showed the uses out here basically consistent with their existing use, which in the case of Birthright was a home converted to a small office, and which in the case of the Fry property were two single-family dwellings. And as we have discussed, the future land use map, anytime we're considering a map amendment as far as zoning goes, the first thing we should do is look at the future land use map and what it says about the property. At the same time, the land use map is not intended to be static. And on page 2 there, which is highlighted from the comprehensive plan, it states where circumstances or land use and development goals have changed, amendments to the land use map may be appropriate to accommodate development that furthers the plan, vision, and other goals of the comprehensive plan. So planning staff identified that these parcels were shown as future urban residential, and that is not consistent with the remainder of Kenwood Park and is not consistent with the public, semi-public land use area, which is our land use category for governmental uses and facilities and in parks. And so the public use zoning district is a potential district in the public, semi-public land use area. It is not in the urban residential land use area. So this application was filed because the current land use map shows that entire area as future urban residential, but that designation is not consistent with or reflective of the plans that have been developed to extend Kenwood Park out to Ohio. So the City of Salina has completed the purchase of the Fry properties and the former Birthright offices. This application was filed to amend the future land use designation for these 3 parcels here, here, and here, and would change, if you're looking at it from a colored map standpoint, essentially change those from brown to blue. And a change to that land use designation would support the expansion of Kenwood Park and the development of enhanced entryway into the Bicentennial Center. It would also be consistent with the current ownership of the property. So we believe that the public, semi-public is more reflective of the current ownership and long-term intended use of the property. The applicant pointed out there's major renovations taking place at the Bicentennial Center, and part of those renovations included improving the visibility of the facility from Ohio Street. The strategic plan urges the creation of a managed master plan, Kenwood Park, Oakwood Park area as a destination area, and these entryway enhancements are consistent with the Smoky Hill River Renewal Plan. So, since there's an agreed upon vision for the Smoky Hill River Channel and Kenwood Park enhancements, and those enhancements be at the Ohio entrance, we think that supports this change. And this is really the only location where you could bring an entryway out that would have arterial street frontage and access. So your role in this item is to decide what your vision is for the future development of this area. Should these parcels continue to be related to the South Ohio Corridor, or should they be connected with the public land use area west of the river channel? Planning Commission felt they should be connected back to the Kenwood Park area, and they made 3 findings: that most of our public park areas have the public, semi-public designation. That designation is more reflective of the ownership and the intended long-term use of the property, and the entryway enhancements are consistent with the city's strategic plan and Smoky Hill River Renewal Plan. So if you were to concur with that recommendation, then under option 1, if you concur with that, you would vote to approve the attached ordinance on first reading, which would essentially cause us to amend the map to take this parcel and these 2 parcels and show that public use land area extending out to Ohio in that location. So with that, I'd be open to any questions about the land use map.
Okay. Questions for staff?
Does it just affect those properties that we purchased?
Yeah, it would just be, this is the birthright property right here. It's that property, and these are the 2 Fry properties. So the amendment would take this blue area, extend it out to incorporate those 2 areas, but leave the remaining corridor as urban residential.
Okay. Thank you. We have any public comment on this item at this time? Okay. Seeing none, we'll bring it back for further discussion and action.
Mayor, move approval on first reading. I'm sure there is a number here, which, ordinance number 15-10809, amending the future land use map of the Salina, Kansas Comprehensive Plan to change the future land use designation of the west side of South Ohio Street, north and south of the Ohio Midway intersection, from future urban residential to future public, semi-public.
Second.
Have a motion and a second to approve on first reading ordinance number 15-10809, amending the future land use map of the Salina, Kansas Comprehensive Plan to change the future land use designation of the west side of South Ohio Street, north and south of the Ohio Midway intersection, from future urban residential to future public, semi-public. Any further discussion? Seeing none, all those in favor?
Aye.
Opposed? That carries 5-0. Move on to 8-1B. Mr. Andrew.
This packet is a little thicker, and Planning Commission discussion was a little bit longer on this item, which is an application filed by Salina Parks and Recreation on behalf of the City of Salina to change the zoning of not both parcels, but just the south parcel here, which will be referred to as the Fry properties, from R2, multifamily residential, to PDD, public use exposition facilities. And we've given you the background there on the history of Kenwood Park. Back in 1979, a portion of Kenwood Park was rezoned from its original R1 to C3 because C3 was the first district in which drinking establishments were permitted, and so 57 acres of Kenwood Park were rezoned to C3 to cover all the buildings and areas that might have the sale of beer or consumption of alcoholic beverages. The C3 district is our shopping center district, and so it's not really very reflective of the Bicentennial Center use. As to the Fry property, it has historically always been residential property. In 2003, the Frys attempted to rezone that property to C5. Planning Commission did not recommend approval of that. The City Commission agreed with that, but asked staff to study the corridor between Iron and Greeley a little more closely. And based on staff's research, they concluded that it was still a predominantly owner-occupied residential area, and because of concerns about spot zoning it to commercial, that request by the Frys was denied, so it has retained its R2 zoning, and you authorized the purchase and demolition of that property earlier this year, and the site has been cleared. So we are only talking about the southwest corner of Ohio and Midway. The application is for approval of a zoning change, approval of the preliminary and final site development plan for the entryway improvements, and those entryway improvements include a proposed electronic changeable copy sign. So if you could go to one of the site plans, John, or maybe the entry planting plan to give a perspective to that, please. The goal of the application and the goal for this property is to extend Kenwood Park out to Ohio Street and create a more visible gateway and entryway into Kenwood Park and the Bicentennial Center. The zoning change is being requested to allow the installation of park-like improvements that you see on this plan, and also a electronic message center sign. And so we identified as a staff 5 items at the time the application was filed that were exceptions that needed to accompany this application. One was that the sign would be located on a separate zoning lot from the Bicentennial Center, with the Bicentennial Center being zoned commercial and these lots being zoned residential. The public use sign regulations limit a electronic changeable copy sign to 100 square feet, and 176 square feet was proposed, with 82% of that being a digital area, and the code that was adopted limits that to 50% of the area. The proposed sign height at 21.5 feet was slightly higher than the 20-foot height limit, and then staff identified an exception to the sign setback. I wanted to clarify that staff looked at that from the standpoint that hopefully long-term Kenwood Park and this extension of it would be replatted, and when it was replatted, Ohio Street only has 35 feet of right-of-way in this location, so we have sidewalks, traffic signs, power poles, those types of things that are outside the right-of-way. And so when we looked at this, we looked at it from the assumption that appropriate amount of right-of-way for Ohio would be dedicated, and if that took place, the sign is 17 feet back from the curb line today, but would be 2 feet back if the additional right-of-way was dedicated. So that is why we identified that. The planned development district is designed for projects that don't fit neatly into standard zoning district requirements. The sign would certainly fall into that category. The plans that you see here were prepared by Convergence Design, the design firm for the Bicentennial Center project. There was an application filed. September 1st was set at the hearing date. There was a public hearing on that date with lots of comments and discussion, which is attached to your packet. At the conclusion of the hearing, the Planning Commission voted to postpone consideration to address three things: to confirm that the landscape plantings are suitable for Salina's climate and soils, to address the pros and cons of converting the Midway, Ohio intersection into right turn only, and to provide additional information about the need for and the justification for a 9x16 digital display screen on the entryway sign. And they also asked for how that proposed sign compares with signs at similar facilities and other digital signs in Salina. Their representatives from their design team was not able to attend the September 15th meeting, so it was further continued to October 6th. As we point out, our public use district is intended to accommodate many of the city's public and semi-public and governmental facilities. It's designed to accommodate the unique operational needs of public facilities, which are owned or controlled and used by the City of Salina or other governmental bodies. The Exposition Facilities Subdistrict was designed and intended specifically for the Bicentennial Center and Kenwood Park, so it's long-term. The hope is that it will not remain C3 indefinitely, that the whole site will at some point get rezoned to public use exposition facilities. The only structure that's being proposed here is a sign, and as we pointed out, the current maximum sign size is 100 square feet, and the current size or height limit is 20 feet, and it must be set back at least 10 feet from the property line, and the electronic message center portion may not exceed 50% of the total sign area. So what the Planning Commission reviewed was a 176 square foot sign with 82% of the sign area proposed being digital. So this was the rendering of what was proposed. So by staff's calculation, we don't look at the pillars as part of it, but the sign face here is 176 square feet. It's 11 feet tall, 16 feet wide. The digital portion is 9 feet of that height with 2 foot static above that. The first thing the Planning Commission focused on was the zoning request, and they determined that the current R2 zoning inhibits the ability to install electronic message center sign that would identify the main entrance and inform the public of upcoming events. They also thought that while you could build homes here, the higher and better use of the property was an expanded Kenwood Park and enhanced entryway to the Bicentennial Center. Again, we were looking to the future, as was the Planning Commission, that someday Kenwood Park will all be zoned public use exposition facilities, and so the request to have that zoning classification here would be consistent with that long term, and the zoning would be compatible with future zoning and the current use of Kenwood Park and nearby residential property if the site is adequately buffered and light spill from the sign is adequately controlled. You've already addressed the comprehensive plan portion of this, but the comprehensive plan makes a couple comments. It says that transitions between civic and institutional uses in surrounding neighborhoods should minimize the impacts of noise, light, traffic, operations, and scale of use. So the Planning Commission made a recommendation on this at their October 6th hearing, and they received a supplemental report from staff. They had detailed comments from the Bicentennial Center project architect They received comments from a neighboring property owner and asked many questions. By a 4-3 vote, they recommended approval of the zoning change to go to the requested plan development public exposition facilities. They recommended approval of the planned improvements for the site, including the sign, and they recommended that 3 of the requested exceptions be granted, but they recommended that the exception to allow the sign to exceed 100 square feet and the exception to allow the electronic message center portion to exceed 50% of the sign area not be approved. And so they gave 6 reasons for their decision, but their 6th finding was that the exceptions being requested have not been sufficiently justified by the applicant, and a sign of the sign requested would have an adverse impact on nearby residential properties. So we have identified 4 alternatives for you today. One would be to concur with the recommendation of the Planning Commission. The ordinance that is before you has been drafted based on the recommendation of the Planning Commission. And essentially, the Planning Commission, as I noted, recommended approval of the change to the land use plan. They recommended approval of the change of zoning. They recommended approval of the site development plan for the improvements to the Fry properties. They recommended that the sign location off-site be approved. They approved the setback being requested, and they approved the 21.5-foot height. They did not recommend the 176 total square feet or 82% of the sign area being digital. So if you chose option 1, you would be affirming the Planning Commission's vote, and the result would be the Bicentennial Center could have an electronic changeable copy sign, but it would be limited to 100 square feet total, and 50% of that could be digital display. You could also, with 4 votes today, override their recommendation and completely deny the application, which would leave the property zoned R2, as it was when the Frys owned the property. You could override the recommendation of the Planning Commission, again with 4 votes, and you could approve the sign as proposed, the 176 square feet with a 9x16 screen. If you you disagree with essentially finding number 6 of the Planning Commission as to the effects that such a sign would have. To do that, you would amend the ordinance that's before you to insert back exception D as far as the maximum size and exception E as far as 82% of the total sign area, or you could return this application back to the Planning Commission for further consideration with a statement specifying the reasons for your disagreement. Additionally, by separate action to focus again on the sign issue, if you don't agree with either the way staff or the Planning Commission has approached the sign question, then you could also, by separate action, initiate a motion to initiate a text amendment to comprehensively review the current size limits on electronic changeable copy signs. So if you could go to that slide, John, identified as electronic changeable copy signs. The focus, admittedly, was primarily on schools, but it would apply to other public uses and other public use areas. But the current limitation in a public use district, if you're an elementary school and you are located on a local or residential street, then the maximum sign you could have would be 32 square feet, and 50% of that could be an electronic changeable copy sign. If you are a high school, or specifically a school that's located on a collector or arterial street, then you could have an identification sign that's up to 64 square feet in size, but the maximum sign area would again be, for the digital portion, would be 50% of the total sign area. And athletic stadiums, which in this case we're also talking about public arenas, things of that nature, the maximum sign size adopted was 100 square feet, with 50% of the sign area being digital. So we use the term athletic stadium here because much of the discussion focused on Salina Stadium at the time that was adopted, but that same provision applies to public arenas. So if you were to want to consider larger signs for public uses or revisit the question of why 50% of the sign area, or the limitation should be 50% of the sign area being digital, then as a city commission you could initiate a text amendment to revisit those limits for all public uses. So it's staff's view that if our regulations that we have adopted are too restrictive on places like public arenas or convention centers or athletic stadiums or schools in general, we do not have a sign area limitation in commercial districts. So we limit the entire sign area, but we do not tell a business what percentage of their sign can be digital. And we have in the residential and public use districts, partially because of their proximity to residential areas. But our preferred approach was if you think the Planning Commission got it wrong, you may certainly override their recommendation and approve the sign as proposed. But if you think they got it wrong or the code is too restrictive, we think the better approach would be to go back and do a comprehensive review of our size limits on electronic changeable copy signs. So we gave you a lot of technical information about signs. We have a lot of graphics in the packet. John, if you could go to slide 16. I think this was, maybe of all the slides or graphics, this is the best indicator of what the proposed sign would look like. What it doesn't display, which is a whole nother technical field, is dealing with illumination and light spill and foot candles and all of those things. But from a viewpoint, essentially that sign is superimposed in the proposed location, we believe, to scale, and that is the proposed type of sign, design, and location. And this photograph is taken 250 feet south on Ohio Street.
What's that setback from?
Well, again, that setback is 17 feet from the curb of Ohio Street. And what we calculated was if the correct amount of right-of-way for Ohio Street were dedicated, then the sign would be set back 2 feet from a future property line. But presently, it sits, that location is 17 feet back from the curb line, west curb line of Ohio.
Just look like it just look less than 17. I mean, it may be just.
And again, from
a
that
distance,
perspective,
yeah.
I can't.
Right.
Because of the perspective, I can't tell you, but that is what the architect essentially tried to take the site plan and superimpose this on there. I can't tell you that you can scale it off there. It's clearly behind the sidewalk, but one of the things we tried to point out to planning commissioners is those power poles and wires that you see there today are actually outside the right-of-way of Ohio, because we've squeezed a 63-foot street into a right-of-way that normally would be 100 feet wide, but in this location is not.
And that's the 21.5?
It's 21.5 feet tall, and so the digital portion running across here is 9 feet tall, 16 feet wide, and then essentially a 2 by 16 foot area at the top. That would be a static sign that would identify the Bicentennial Center sign. What the architect was trying to convey was screen size and the type of letters that you would, the size of letters that you would need to be legible at certain distances. So that's what most of the discussion focused on, but the 9 by 16 is not needed solely for text or letters. It's also needed for the graphics and messages that the Bicentennial Center would like to be able to display on the screen.
Do you know what the size of the letters are on that architect's rendering?
This one here?
No, the one that had the text on it from the 250 feet away.
Well,
oh, is that the sign?
No, John, go back to the 216. What he's done is he's done this, but he's got 10, 12, 16,
right.
20. So what he's done is the top row, like an eye chart.
Right.
Those are 10-inch, 12-inch, 16-inch, 20-inch.
If we were to approve the sign as proposed by the Planning Commission and we initiated a text amendment, could we catch up to the sign with the text amendment before they built the sign?
I'd have to defer that to the applicant, but I believe time-wise that the time is not of the essence in terms of installing this sign. There was some discussion of it occurring in the spring, but I think that's best addressed to the applicant.
Dean, do you know how large that sign is on Oakdale Drive? I mean, do you have an
Yeah.
idea what that is?
John, do you want to put that up there? I have it in my thick packet, but this is roughly 94 square feet total, and the bottom portion, it's roughly half and half. Again, it's 46 something square feet here. It's 2 feet 4 inches high, and it's 20 inches wide, or 20 feet wide. Excuse me. So this digital screen here is 2 feet 4 inches to here. It's 20 feet across. This is roughly equal in size. The total square footage there is right around 94 square feet total. So it's roughly half the total sign, but this is roughly equivalent, but it's the screen area. This is a very limited screen. It's very linear. We had 2 others that the Planning Commission looked at for comparison. I guess that'd be 4 and 5, John. This is a sign that was put up at the Masonic Center. The electronic changeable copy portion is 4 foot by 10 foot, so that would be 40 square feet. Again, the one proposed is 9 by 16. And then a lot of people asked about this, and this sign is about 5 feet 9 inches high and 9 feet across. So I think our calculation was it was about 52 square feet, the digital portion.
Dean, how big is the in size, and then also percentage of electronic? What are the dimensions of the sign that we just approved for Kansas Wesleyan?
What we informed the Planning Commission was that again, the rear of the scoreboard is quite a bit bigger structure. So the structure we're talking about here would be 11 by 16. Their scoreboard is 25 by 18. The digital portion is 4 by 13, 52 square feet. So by percentage, the digital portion is about 12% of the total rear of the scoreboard. So it's 450 square feet total. 52 square feet of that is digital display.
So is that all signage?
The two parts of it are athletic schedules. The other part is advertising signs, as well as on their scoreboard, there's a reader board across the top that says Kansas State or Kansas Wesleyan University. And so that basically the whole 25 by 18 rear of the scoreboard is devoted either to having Kansas Wesleyan University, two athletic schedules, and then static advertising panels, and then there's a 4 by 13 area that has electronic changeable messages on it.
Okay, and that's one directional. Is this two directional? That'd be both sides?
Yes, it would
Okay.
face both directions.
Okay.
This sign seems a little bit different to me than signs like the Bank 6 sign, in that it would require to communicate a lot of information about upcoming events or whatever. And so it falls, in my mind, in a little bit different category than the signage that you see around town with electronic message boards on them. And I consider it to be kind of mission critical to the Buy Center to have good communication to cars going up and down Ohio about upcoming events. One question I had was, did you have any comparables in terms of sports arenas and their type of signage?
Well, we made that a homework for the item for the design architect. The only one that they were able to find was the Topeka Expo Center sign, and they found that the overall sign size was slightly larger, but the digital portion of that sign was 8 by 14. And that's the only comparable as far as other arenas or those types of things. Not every arena is in this same setting, but I believe if the architect were here, he would say that the 9 by 16 sign proposed is, and John, if you could go back to one of those photographs or whatever that showed the simulation of the sign. So the idea being that the screen size is not needed so much just for the text portion, but to also convey other aspects of the message. So the 9 by 16 sign was based on the types of messages they were trying to convey and the information that they were trying to convey in total.
The other thing that I think would be critical to this type of sign is that readers, that are cars going up and down Ohio, would be able to actually comprehend what's on the sign as they're driving at 40 miles per hour, and then have a little peripheral vision to see what's up there. And my thought is that science, rather than whatever numbers we want to fiddle with, dictates the size of the sign, because you want the sign to be effective. And if the sign's not effective, if the sign's not the right size, there's no reason to have the sign. Period.
Yeah, I think though you need to balance that with the residential nature of the neighborhood.
I think you can do both.
How far is it to the south of the sign before you get to the first residence? Or I think it's an apartment building?
Well, the Lazy River Townhomes is the closest building to the south.
I'm assuming they would get a fair amount of illumination from this in the
Yeah, there
evening
there
time.
would be, as explained, light comes out here. It's not completely going to go north or south. There is going to be some light projected out this way and out that way, but the primary illumination, what we tried to explain to the Planning Commission that with automatic dimmer controls, which these signs are required to be equipped with, the sign actually needs the most illumination at high noon, where it's competing with the sun. And so what the automatic dimmer controls do is they sense the amount of ambient light, and as it gets darker, then the actual illumination of the sign is reduced because you don't need as much illumination to be visible when it's dark than you do during the daytime.
You could also restrict it by the time that the sign is on.
Is it designed to be on 24/7?
No, so you will see that it's both by the code that was adopted and also one of the conditions that the Planning Commission recommended that's in the attached ordinance was that the message center sign shall not operate between the hours of 10 p.m. and 7 a.m. except when a scheduled public event extends beyond 10 p.m. The sign may operate no later than 30 minutes after the conclusion of the event, and that was actually based on the language that you adopted as far as the university district goes for Kansas Wesleyan or other educational institutions.
I think that's a reasonable thing to expect too, because it's a residential area and that should be shouldn't be lit way past midnight. So, I mean, I think that's reasonable, 10 to 7.
Well, I should preface my remarks by saying I think the sign is definitely needed, but I'm also thinking about someone who may get up at 6 in the morning to go to work. Even at 8 or 9 o'clock at night, that's a lot of light. Is there a way to put short trees or some way to block some of that illumination that's going to come directly on these buildings south?
Well, the only way that I could think of where you could shield some of that light projecting to the east or the west is that you would literally have to design the sign so it was a little more recessed. We do that with what we call shoebox lighting for parking lots. Basically, you put some shields up or you put sides up so that instead of just having a flat digital screen that's flush with the sign, that you would put some sort of elements on the side of it where it was recessed in, and you'd have shields on either side, which would help prevent some of the spill going to the west and directly to the east.
Well, there are headlights driving down that road every night too. So, I mean,
there's light.
Yeah,
Street light.
And you do have a little bit of the way the landscaping is done there. It does offer a bit of a buffer to that residential that's set back off of the street.
Well, the other thing about these elevations, John, if you go back again to our photographs, well, the one thing that this particular elevation doesn't give you is that there's a lot of existing tree canopy there, and so this kind of makes it look like a stark, wide open area, but there's actually a number of mature trees there that are being retained and weren't part of the demolition. That will help with some, but the only way I can think of to shield some of the light projecting across would be to recess the sign back and then have sides to it that would focus the light more directly to the north and to the south. And that's what we do with a lot of parking lot lights. We put shields on the sides so that the light is cast down and not out to the sides.
Which I think the neighbors might appreciate. Yeah.
How would that affect the readability of the sign?
Well, I don't think they would be a great length, but you would just have this screen here would be recessed back into the sign slightly so that what's framing the sign, so you wouldn't have it just flush with the sides, that you would have, it would be like a picture frame or something where it would be inside a frame, and it might be 6 inches, it might be 8 inches. That would just be an edge around the sign and help contain some of that spill, but the size of the screen is going to be the same, and it shouldn't impede the legibility, but I would want the applicant to speak to that as to whether they thought that would interfere with the visibility at all.
Just personal taste, was that the only design for the pedestals holding this thing up?
Part of the design for the pedestals, it was explained to us, is that there is some electrical equipment components that are contained inside the pedestals. And then again, the sign is elevated to protect it security-wise from vandalism or tampering or anything else. But as I understand it, these are not purely for aesthetics. They also have a function in terms of there will be components enclosed in there. But again, we might want to defer that question to the applicant. I think one sign we looked at that was somewhat comparable in design, and you can look at, it does not have electronic changeable component, is the Dillon sign at Cloud in Ohio. It has similar pillars and then the sign elevated on top of it. The main difference is that the Dillon sign is narrower across the width and it's a little taller that way, so it's almost like turning this on its side.
The functionality I can appreciate. The pedestals just look kind of boring to me. But and kind of just in your face,
Well,
particularly for a residential area.
Kind of bulky.
That's the word.
I thought the same thing. Reminded me of a sumo wrestler when I looked at it. But we can work on the final aesthetics
Well, I
as
think
well.
is your question then that within approving the PDD development plan, is it a final development plan or is it more conceptual? I mean, is it open to tweaking or is it?
We would treat, John, if you want to go back to the site plan. We would, I mean, this is open to tweaking and revision by you, but basically it is this piece right here that is, this is the proposed development plan for this parcel, including the landscaping, the sidewalks, the elements here. It might very well be done in phasing, but if there are revisions or aspects of this development plan, this would be the appropriate forum if there were things that you wanted to direct the applicant to revise or adjust.
Okay. There's just a little confusion on that plan because there's certain things on there that say future walkways and
Well,
viewways.
this is not going to happen all at once, and one of the drawings we had head-in parking here, which we eliminated, and then they proposed some trailhead parking over here with 6 spaces. That's not likely to happen right away, and this median may not go in right away, but again, I would defer some of those questions to the applicant.
Okay. All right, any more questions for staff? We'll,
I just wanted to summarize is the way that staff interpreted the Planning Commission's action is that several of the planning commissioners who voted against the motion were receptive. They may not have been receptive to 176 square feet, but they would have been receptive to something larger than 100 square feet. And so their reason for the split vote, and that there were some on the Planning Commission who thought maybe the 9x16 and 176 was too large, but they might have been receptive to something larger than 100 square feet to accommodate the unique mission of the Bicentennial Center, but it did not get to that point. The motion was to exclude those 2 exceptions, and if those are not there, then you're talking about 100 square feet only. So the example I gave is envision an 8x12 sign, and 4x12 of it is digital. That would be allowed by right, and the applicants indicated to us if that was the limitation, it was not worth pursuing.
Is some of the effect of the size of the digital portion lost if it's just lowered 12 inches closer to the ground, so that you don't have as large a screen as high up in the air?
Well, I think what may be for its size, most of the signs that are comparable are actual a little more in the air, but when we reviewed it, we actually came to the exact same analysis and conclusion as the Bicentennial Center's architect, that if the goal or one of the primary purposes of the sign is to tell people who are traveling south on Ohio at 40 miles an hour that they need to get into the right lane and they need to turn at Midway for the Bicentennial Center or they'll drive by it, is that needs to be visible north of Gypsum. And so you're talking a minimum of accommodating 12-inch letters to achieve that because of the 40-mile-an-hour speeds on Ohio. And I'll let the applicant speak to that, but the lower you go, then you have to be worrying about the visibility in terms of the distance at which you can see it from. But it is what we would consider a pole or pylon sign. It's not a ground sign, and we have some banks like the Rose Hill Bank on Ohio where the sign is basically at ground level. Obviously, you want, when people are driving, a sign's 50 feet in the air and they're driving, they oftentimes can't see it because it's out of the view of their windshield. So this was kind of designed so that wherever the height is, that it fits within your windshield view as you're going along Ohio so that you can see it.
Commissioner, with regard to that, the variance or exception to the sign height is a foot and a half, 21.5 feet versus 20 feet. I probably to take that question a step further is 1.5 feet make a difference if you wanted to keep it at 20? We could ask him. I'm thinking that's probably not the most sensitive aspect of it.
I don't think that's the exception of greatest concern to me. That what was explained to us as a staff is that these heights and these clearances were put in there to keep the sign, make it secure from tampering or vandalism or anything. So that was part of the design, was to keep the sign face up so it's inaccessible. And the sign supports at the Kansas Wesleyan scoreboard they're not brick like this, but they're right at the same height, again for the same reason, so that the electronic components are not reachable from the ground.
Judging by the creativity of graffiti artists in this country, you'd have to go up about another 70 feet to make that safe. But
probably to keep it fully safe. One other thing too is when you look at this, our current standard bases the size of the digital portion of the sign to not more than 50% of the total sign, which I'm not quite sure I understand why that is, because quite honestly, when you have that type of a screen, you don't need most of the rest of the other sign except for possibly the static area for the name, Bicentennial Center or whatever it may be named in the future. So you really don't need the rest of it for that. You really need to maximize the digital space because that's the portion that changes out for purposes of informing people about events and things like that. So when you look at it, you could look at it and say, wherever you come up with on the size of the sign itself, you could say, well, you could either change the percentage to maybe 75 or 80% because the rest of the space this protects is kind of worthless space, or simply have a maximum size for the digital portion as well. So you could look at it a couple different ways.
Well, in particular here, because it probably wouldn't be advertising on this, and wouldn't be any schedules or.
But to reiterate that, and we treat our residential and public use districts differently. If you were in a C5 zone and you wanted to have a digital sign, it wouldn't be limited to 50% of the total sign area. It would be what the business gets so much square feet of sign area, and if you want it to be all digital, it could be all digital. Mm-hmm. So that would be one of the things that we would go back and look at if you were to initiate a text amendment to revisit the entire. We wouldn't just look at this sign, we would look at all of our digital signs and any future signs for our high schools, Salina Stadium, any of those types of things. The reason that what I tried to explain to the Planning Commission is we did the best we could coming up with a 100 square foot limitation, but that doesn't mean it's right, because we don't have anything to measure it against, because this is the first application that we've had under those sign regulations, and the 100 square foot could be too restrictive.
The overall size of the sign isn't concerning to me, and I think the real future is that electronic changeable copy, and what technology will do with that. They just jack up the lumens brighter and brighter and brighter, then it kind of becomes an arms race with the size of the sign.
So we do have folks from the Bicentennial Center, and we also have some property owners on South Ohio who've been waiting patiently, so I'll give them a chance to speak.
Okay, and we'll have the folks from the Bicentennial Center come up first, and while they're coming up, I'll just clarify, because I've been kind of taking a tally in my head. So you're concerned more with the size of the sign and not so much the percentage.
Yeah.
So if it were a smaller and 100%.
I mean, the overall size of the sign does not concern me, but
Okay.
The electronic can be overdone.
Okay.
Yeah.
Okay.
Face kind of stuff.
Good evening. I don't know that I have a ton to add, but a couple things that came up. Regarding the design, it's fairly simple in nature, but it was designed for a couple of things. One, so traffic exiting and entering the building wouldn't block the display as cars are driving by, just simply waiting to turn left or right for the elevation. Two, for the vandalism or potential issue from the casual vandal, maybe I can say. But in addition, as far as the design standpoint, it was, although simple, really kind of set to measure what the building looks like today. It is brick on the lower half and metal on the top, and that was kind of the understanding, is that we were trying to tie these two structures that don't neighbor each other together in some way with similar color schemes and looks. So I'm not to say that they couldn't go back and maybe do some other additions or some adjustments to that, but that was the original intent when it was put together. Again, and I don't know that I can speak clearly to this, but the question came up regarding the south property behind the second Fry property. I don't know if there's a way to do a Google map image of that, but I'm fairly certain that there's no windows on that side of that facility at all. They are only on the rear and in the front. It doesn't mean that it doesn't affect the other properties across the street or on the north of it, but as far as the south, since that was brought up, I can't say with 100% certainty, but I'm fairly certain that there are no windows that would be directly facing that sign on that side in that direction. I'd be happy to answer any questions if there are for me.
Ron, if you could one of the questions earlier had to do with the time that the governing body has if they're looking at a text amendment, and the kind of how that works out with the timing of the project when this comes back to us. And I think this is intended, this is part of the last three pieces, kind of a late May, early June. Is that pretty close?
Correct. The construction company actually provided the GMP, I want to say this week. And the project wouldn't look to commence until mid-June of 2016, with completion towards the end of August, middle of early September time period for completion of that portion with signs and whatnot. So I can't specifically speak to when they would need to procure that, but I could not envision it's more than 6 months out. So we still have at least 3 or 4 months.
Was there any consideration towards, and I forget the technical term, Mr. Andrew, but the setback or little sleeves to restrict the spray of light across the street?
Not to my knowledge. First, that's come up.
Yeah, I think that might help. If it were fixed similar to, what, I don't remember what he called it, but
like an
Dean
inset,
was talking about
to inset the sign,
sort of
the
the
digital portion
sleeve
into
on
the sign.
sides or something.
I don't think that'll affect visibility from the roadway. You're going to be
No.
headed right towards it, so it couldn't hurt.
Well, is the digital display on this, I mean, is it something that like shoots, I mean, is the light coming out, or is the light, I mean, because that's hard to look at. I mean, it seems to me it would be designed in a way that would be a lot easier on the eye to look at. And, I mean, it's not individual bulbs sort of out there, is it, or is it?
Difficult to me for me to really answer that question, I guess, in some professionalism as far as the sign quality and whatnot. But my understanding is that obviously it would diminish with the levels of light from outside, whether it's sun or whatnot. That thing would auto-regulate, and then with the controls turning off at a certain period that was deemed appropriate. As far as the amount of light that comes out, I know that our design team went through a whole mathematic equation on the foot candles and whatnot. I don't know that I am capable of doing that, but I know that he came up with, it was a 1 foot candle at 330 feet of distance was what he get at max light. At max light would only be at high noon, if you will. So I'm not sure how that would downgrade as they got into the evening or into the darker period, but it was a fair less bit than what I would have originally would have.
I think the biggest concern would probably be when it's darkest, because then you're have the highest opportunity for the flash. And so my thought was, if it's more of a video type board versus just those little individual lights that are on the other sign at the Bicentennial Center, they might tend to be a lot less obnoxious than and bright and kind of flash at you. And so you don't know that if it's a video display or...
No, it is a video display. The technology would be far greater than what we
Okay.
have currently at that location. I don't know that I can give you any
Okay.
technicality to it.
Because I've seen some of those, and those aren't as blaring.
In your
Correct.
face.
Right.
So it wouldn't be as distracting as the one at Crawford and Broadway. Which is
Easy
actually-
cash.
Which is, I mean, it's
Habla
actually
español.
Easy cash.
it's a distraction to
Yeah, okay.
to drivers, yeah.
Yeah, Commissioners, one thing too, when somebody talk about flashing, now the picture would change, but as far as off and on flashing, that wouldn't happen.
Right.
Wouldn't that be an issue?
Yeah, that would be very annoying.
Yes.
Okay. Quick question relating to Mr. Andrews' comment about something about the sign maker saying if it were a certain size, it wouldn't be worth doing. What is the threshold of that size, do you know?
Well, the information that was presented at the last meeting was that the calculations that our design team went through from the United States Sign Council, they actually said that the sign size should be 206 square feet, which is what
206?
correct. However, they proposed 144 for a number of reasons as they kind of put together their design. So, from my understanding, I think there may be a little bit of give. I think the discussion was at 128, I believe. Is that? And from there, they would be hesitant to do much more due to the fact that there's not a stoplight at that intersection, the speed of travel, and some of the other number of factors that are kind of weighed in to get our message across, that at some point we would just lose them as they drive
They
by.
wouldn't do less than 144. They wouldn't do less than 140 or 128.
128.
They wouldn't do less than 128.
Is,
Correct.
Ron, is the 128 the total sign size?
Would be the digital copy size. I
Digital
believe.
copy
Correct.
size. Okay, I want to make sure.
And
you're
the
clear.
140, so that would correspond to 144.
144 is what is currently proposed, the 16 by 9. And the proposal for the 16 by 9 is merely due to the fact that the 4:3 ratio is a fairly standard. So as we begin to mess with that scenario, it begins to make more work on our end to reformat images as we've received them from different events to put them on the screen appropriately, which is how we inevitably got to that number.
Okay.
So this could actually be used to show excerpts from games, or, I mean, if you were so inclined to.
Could be a
It's
monster
a true,
truck
it's a
crushing
true
a car.
video.
Sure.
Video screen.
Okay. All right, any more questions for Ron? No? Okay, thanks, Ron. Okay, we'll go ahead and hear public comment from residents in the area at this time and kind of hear what you guys have to say. Thanks for waiting so long.
Well, my
and
name
if I
is
could, yeah, your name and address.
Carol
Thank you.
Rucker, and I'm talking about the property just a kind of catty corner across the street. And at the other meetings, they've been talking about the illumination of 250 feet as you're going down that road. Well, can you imagine at 250 feet, if you're reading that sign at 250 feet, how bright it has to be? Can you imagine how bright that is right across the street? And what he's talking about, that there's no,
Oh, I'm sorry. Can you come into the microphone? Thanks.
because there's no
Getting messages from the booth back there.
windows on that side of the house, on the south side that he's talking about. There is no windows on that particular side, but there's windows on the front of that house where that is going to be shining out to the side right in their front windows. It's going to be on my particular property. It's going to be on the front of the house and to the side of the house, the same way with her property. And the house that's right in front of that, Kay, is your parents' old house.
It is.
Can you imagine what the light's going to be at that particular house, where it's going to be blaring? Because there's nothing to stop that light. It's going to be ridiculous, and they're talking about using it as advertisement to help pay for all of this. So you're going to have advertisements running non-stop on that to advertise whatever their Coke products or whatever products there. And then if they do what you just said about having excerpts from particular the game, can you imagine people going down the highway if you're that street? If you're lucky, they're only going 40 miles an hour. Most of the time they're going more than that, trying to watch that game, and people coming in and out of the midway, plus going north and south. They're going to be watching that instead of the traffic. And you're going to have a lot of accidents happening on that street. They talked about there was only 7 accidents in a year, but that's not counting all the almost accidents that happen every day there. We can't even get in and out of our driveways. We have to go through the alley and go back down Connecticut, or, because it's just ridiculous to even try to get in and out of our driveways because of the midway. Right now, they're pulling out of the midway, going crazy to keep their speed up with the people that are already going 40 to 50 miles an hour on Ohio. They have come up into my yard, over the curb, and then down because they can't, to pull out at that speed to make that turn. They're missing it. And they're coming up into our driveways and then into the yards, the way it sits right now. Well, if they're going to be looking at a sign, reading it as they're coming down the road, that's going to be even worse. But the thing that I brought up at the last meeting is that we've asked twice now and nobody's addressed, what is that sign going to do to the property value? I hear, well, that little park area is going to enhance it, but they leave out the fact that glaring sign is right there. What's that going to do to all of our properties along the east side of the street and north and south of that sign? What does it do to that? Nobody's given us any answers on that, just that it shouldn't cause a problem. But would you want that in your front yard? That sign blaring like that, would you want that in your front yards? And if you're trying to sell your house, do you think people are gonna wanna buy it knowing how bright that is? We're gonna have to put blackout curtains or something on from that light to going into the house. And forget sitting on your front porch, you can't do that. So that was my question. I think the 9 foot by 16 foot is too big. I mean, we're going to get a sign one way or another. They're wanting it for the buy center, and it probably needs to be, but the only people that's going to affect is the one coming in off of the highway to go down Ohio Street. That's not going to solve the problem from all coming in off 9th Street and Crawford Street. That has nothing to do with those areas. It's just Ohio Street coming off. So that's my questions. What about the property values?
Okay. Thank you.
Mm-hmm.
Okay, couple questions there. One on the brightness, and I think we've kind of hit on that one several times, but the new information that kind of came up was information about 246 feet or 50 feet or whatever that was.
1 foot candle at 330 feet at its height.
How does that?
You have to get up here.
Yeah, come on up to the mic.
At its brightest, it's 1 foot candle at 330 feet. I couldn't tell you
And
what
is
that
that
measure means as far as how bright it is.
But is that at noon?
Yeah, that's at its brightest. So at 10 o'clock or 9 o'clock, it's not going to be at 1 foot candle at 330 feet. I couldn't tell you what it's going to be at that far.
But as far as how, I mean, when we get, if I'm 250 feet away from this thing, can I turn around and read something? I mean, is it that bright, or is it just that I can?
From my previous
I'm
experience
seeing
and
it.
the boards that we have installed on our construction projects at night, you could be at 250 feet away. You're not going to be able. You're going to get more light from the street light than you are from that sign. At 250 feet, as you get closer, yeah, you can. If you're on the midway, you could probably be in your car, and read something because it's right there. But you get 250 feet away.
And does that, obviously the size would be a consideration on, I mean, if the sign
Somewhat,
were
as far as
206
maybe
square
as it's
feet.
as much as it's spray, but the brightness doesn't change as far as the size.
Okay.
You've done other signs at other
Not at
locations?
facilities similar to this one. We did one that was right on a 6-lane interstate, but even that one had to have dimming, reasons, especially on it. That one, that's like 55, 60 miles an hour. But from my experience, I was just speaking from my experience as far as seeing the light output and being at certain distances. So.
Are there any other video screens in Salina?
As in signs?
Anything comparable, analogous to?
Well, when you say video screen, you mean like playing excerpts from stuff?
Well, I mean, this is basically a large video screen, correct?
Well, it can be, but I don't
or
think.
digital screen. I mean, by video, but
Oh, digitals.
as opposed to something with lights that.
It's
flash.
LEDs.
Well, is this an LED display, or is this a digital display? Because it sounded like it was a
So it's not
digital video display.
It's not a digital display like a TV. It's a bunch of red, green, and blue bulbs that they're LEDs, but
Okay.
the red, green, and blue combines to create all the different colors, including white. Don't ask me how that works, but
Okay.
so basically you have panels. It comes in panels. Each one has a certain amount of bulbs on it, and then when you combine them all, then it coordinates with each other and creates one big picture.
Okay.
Well, girls, I don't think there's any way around the fact that you're going to get a sign there. So I don't think, I mean, I understand where you're coming from because of my old home place there is going to be lit up like daylight. Well, it is.
I don't know that we really know what the light's going to look like.
Well, it's going to,
Especially-
if you're going to see it from down the street, you're going to see it bright. I mean, it's going to be bright.
Commissioners-
Or how much
for an
village
evening.
there is.
Not necessarily, and I can't say that it is or it isn't because I'm not an expert with those signs. But there are signs that, if they're large enough in our community, as you go down the road, you can see from a distance. There are different types of signs. They may be hollow, where there's lighting inside the sign and it lights up just a plastic face. And as long as the letters are the right size and the contrast is fine, you can see them from a big distance. And they don't light up your vehicle. I think you're right in saying it's difficult to envision not whether you can see it from a distance, but the emittance of light towards you from a distance. That's a different phenomenon, and I can't describe what that is. But so I can't say that at 100 feet, 50 feet, whatever, that you wouldn't be able to read something. But I can't say that you would either. I don't know that, but I don't. Just an assumption that it's a large sign that you can see from a distance doesn't necessarily mean it lights up your vehicle.
They
or
go
your home.
off at 10. They go on at 7.
Yes, or whatever time.
So
that if
during
you, yeah.
so during the summer, when it's not super dark at 10 o'clock anyway,
Right.
it's last probably the biggest time you're going to have it on is going to be in the winter. Okay. Well, let me just ask this so we can get this rolling, and that is that with the PDD, I mean, there were a number of things that we really didn't talk about, and those were the right turn only off of Ohio, and I'm assuming that everybody is good with the turn lanes going in and out of there because that is a component of that PDD that we're going to want to. That's
If I was coming through there at 2 in the afternoon with no function, I'd like to be able to make a left turn. But if it's a large event coming out, I mean, it just depends.
well, you're going to have
Yeah.
Greeley open now. So
Yeah.
if you think about
And I
it, you
think
will
there'll be
have
very
Greeley.
few big events where that is a problem, and those could be anticipated, I think, and you could have law enforcement out there, traffic direction.
Yeah.
Historically,
We're leaving
commissioners.
a Liberty game or something.
Yeah, the best example, I think the Liberty is a very good example. The Bombers, historically, what's happened is at the end of a Bombers game, they have, if they anticipated a big crowd, had the law enforcement out there to direct traffic, and that makes a big difference. But I like to think that we're going to have so many events that it happens quite often, but the realistic aspect is you don't have events in that facility that bring you 3,000 or 4,000 people all that often, and so typically the traffic is pretty dispersed in that way. You'll have those peak times, but we can accommodate those peak times in the same way we do right now. It wouldn't change.
Because if you're anticipating Ohio Street being a conduit to the freeway for a lot of folks coming in, I think they would appreciate being able to make that left turn to go right back up to the freeway.
Absolutely.
So, and I take it the zoning change is fine and all that. I mean, we're good. The only sticking point we're talking about is pretty much, and what I'm hearing from most people is the size of the illuminated.
I
part.
think
So if
basically, I'm sorry. Go
we
ahead.
could come up with a not to exceed on the video, for lack of the display.
Well, we want the light to go up and down the street, but not across the street. I mean, and that's where I think, I don't know if it can be engineered, either recessing it, putting a little lip on it. The old walk and don't walk signs and traffic lights. If traffic's coming at an angle, they actually are physical sleeves. There's some cars over here, you can't see the light, and only the cars that you want to see it. The actual physical sleeves would detract from the sign, but I don't know what the engineering capability is.
I would not think it'd be that difficult to, in essence, have the sign inset to a certain degree, a few inches within the digital portion of the sign, and the screens inset into the sign, versus to have some type of edging or something. But I can't fathom that'd be difficult.
We need that in the motion.
And,
Not
and
sure
just
what to tell you about your motion.
one other question, and I'm assuming this
Recessed.
document we just got is a reworked version. I guess I don't
Actually,
tell you
we
exactly what it
recognized
is.
it had been omitted from the
ordinance.
packet, so.
Yeah. This says the setback at least 10 feet. Now, in the diagram, it was 17 feet. So can this 10 be made at least 17 rather than at least 10?
What the planning commission did was that they allowed the sign to be closer than 10 feet from the property line in anticipation that the property line was going to move at some point in the future.
And we'd still be able to do sidewalks in there and no problem, and not have it right up against the road.
We've got the site plan pulled up right now, and I'm not sure I can tell. Dean, can you describe as far as any perimeter sidewalk, the distance
gonna
from
have
the
a side-
roadway?
Their plan is to have this, there's an existing sidewalk there today, but their plan is to
Come in behind
rebuild
the
that.
sign.
Physically, Ohio Street's not going to change. What we're primarily looking at is that today we have the very unusual situation that the property line for Ohio Street is the back of the curb. And on most of the other sections of Ohio Street, we have anywhere from 15 to 18 feet behind the curb that's right of way, where you would have sidewalks, traffic signs, fire hydrants, power poles. We don't have that in that section of Ohio. So when we looked at it, we said the sign location is 17 feet from where the property line is today, but if we took the right-of-way line and we moved it back to put all these utilities and everything in the right-of-way, then the sign right there it's only going to be 2 feet from the new property line, but it's still going to be 17 feet from the street. The street's not going to move, so its relationship to the street will be the same. The only thing that would artificially move would be the right-of-way line, just to put those types of improvements in the right-of-way instead of in easements.
Because I think the neighbors are more concerned about the number of feet from Ohio Street curb rather than the property line. I think they want to know where is this sign going to be in relationship to Ohio Street.
So what I can tell you is we've gone out there and measured it, and this right here is 17 feet from the curb line of Ohio, And if the 15 additional feet were dedicated, then it would only be at 2 feet. And so the exception that the Planning Commission recommended was based on staff's, what we didn't want to have happen was that 5 years from now, Ohio Street is replatted, and then we've created a non-conforming sign because, oops, the setback was okay before, but now it's non-conforming. So we were just trying to anticipate that happening in the future and addressing it now.
So is there any way the 17 feet is protected in this document?
Well, it's protected because the last condition in the ordinance and the recommendation from the Planning Commission is that development of this property shall conform with the approved site development plan, which means this can't move. In your action today, if you approve this, you're approving it in that location.
But in relationship to something else that can move. But there's...
The right-of-way is the only...
In the way that no one except maybe me is going to notice that the right-of-way line moved. The curb's not going to move, or nothing's going to physically move. It's just a question of, are we going to have 35 feet of right-of-way with everything else on private property, or are we going to have 50 feet of right-of-way? If we have 50 feet of right-of-way, the choices would be to say, well, this is going to be 2 feet from the new right-of-way line. If we want it to be 10 feet from the new right-of-way line, then we got to slide the sign to the west 8 feet.
Right,
And
but there's a blank line in this, in C, 2C. What I'm asking, is there any way that the way it's written now, that 17 can change?
Well, I don't know why that's there.
Okay, so 2 feet, yes. The blank would be 2 feet, and again, that's projected to the future to keep it from being non-conforming.
Right. Yeah.
So the sign, as it reads today, would be 17 feet away from the property line, which conforms. But our concern was if we went in there and replatted the Kenwood Park addition and got the appropriate amount of right-of-way, that the sign would end up being a 2-foot setback. So we just want everybody to know up front that it's not going to get any closer to the curb, but this right-of-way line that's on top of the curb line today could move over to here to accommodate sidewalks and things like that. And if that happened, then the sign would become non-conforming, and we don't want the sign to be non-conforming. We want it to be conforming.
I just didn't want the neighbors to wake up one morning and that sign be closer.
Right.
Okay.
Well,
I'm listed in the phone book. I just want to make sure that they're happy. Okay.
We've got all kinds of measuring tools, and we go out and measure stuff every day, and we will make sure that they put it right where it shows there. If that's where you approve it, that's where it's going.
Okay. Don't know if I asked this, but was there any other public comment? And then, since there isn't, we'll close that, but we'll go ahead and I don't know that there's any answer to the property value question without.
There isn't, because you can't predict property value impacts in that way. So property values could remain stable, they could go down, they could go up. I wouldn't state they'll go up. I don't think that would be responsible to do that. But there's no indication or reason to necessarily believe they'll go down either. Quite honestly, traffic is probably one of the biggest impacting factors of properties along that road. It's a busy 5-lane road.
Okay. Sorry, I wouldn't have a good answer for that one, but we tried. Okay, to go to, we'll bring it back and we'll get moving on action here. Let me maybe try to help this out a little bit. And it sounded like there was kind of where I am on this is we're going to need a sign. It sounds like we have room for a compromise on there. Sounds like if we could do 128 square foot of electronic changeable, that would be doable, and it's considerably less than 176 square feet. And then I would think from a design standpoint, 82% would still allow the same sort of proportions and design.
Yeah, Mayor, I believe the 128 is the digital size, and that
Right.
compares to, I believe, a 144 proposed digital size.
Right. So the total sign size is 176. The digital
Okay.
portion's 144. What was discussed was 128 square feet digital, but you'd still have to accommodate the rest of the sign, which would put the total sign at 160 square feet, because you'd still have the 32 square foot portion at the side.
Okay, well, it seems like from everybody's comments and so on, what'd you say, 160?
160, so if
That
Right.
wasn't, that wasn't the real issue? It was
No,
the
it was not the total
changeable-
sign, it was the percentage of the, so if you are 128 square feet, basically you're looking at an 8 by 16 electronic changeable portion instead of a 9 by 16.
Is there a reason to have a percentage limitation on a sign like that? Or have a designation for, this is the maximum amount of signage, and you determine what that ratio is by what you put on there and what fits and what looks good together.
Well, our suggestion was that even if you decided today to allow more than 50% of this sign to be digital, that if you did that, we should still go back and initiate a text amendment to go back and look at whether that 50% limitation is defensible.
Okay.
Is there a way to take action this evening and still ask for an engineering assessment for reassessing the screen to see if it's feasible? I may be the only one who's interested in that. I don't know.
No,
I-
I agree. That would kind of
Yeah, I don't think that's a difficult question, actually, or difficult issue. But what I could say is that if you know what you would accept if that's not the case, it would be helpful for us to know, because then we know how difficult that issue really is. But I can't fathom that's a difficult issue to inset the sign. It's going to be, I think the real factor is how much space do they need electronically for the two faces of the sign and the space between, and what effect does that have on the width of the sign? To me, that's probably the main factor. But I can't fathom that that's a difficult issue. I just wouldn't expect that at all. We could always come back, I suppose, but I don't really see that being an issue.
Does that need to be written into our action this evening?
Yeah, I think it'd be a condition of approval of the size if you want to exceed the currently allowable size. And I think you'd want to specify how many inches that you'd like to see the digital portion of the sign inset into the sign.
Well, and that's where I would need the expertise of an engineer. I wouldn't know. I would have thought 3 or 4 inches would have been enough, but obviously it sounds like maybe it's more. But I honestly will admit I have no idea on which to base my guess.
I agree, that's for other people to know.
So I just need clarification here. We're doing a sign, and what's the minimum effective area of the electronic portion? What's the minimum effective size?
It depends. If you go with a ratio and you say that the total sign can be up to 160 square feet, if you take that times 80%, you say rather than 50%, you believe 80% makes sense, because quite honestly, you don't need the rest of the regular sign for anything but the name. That would put your digital sign face at 128 square feet. So you'd have 128 square foot digital, 160 square foot total, which is an 80% ratio.
What's the 80% have to do with anything?
Nothing really. I think it's just about as easy just to say to have a total for both.
Yeah.
And I do believe that when you're dealing with that type of a digital sign, you don't need much of the regular sign. In fact, you could literally have just a digital screen as well. I'm sure that's out there somewhere, where that has the name of the facility on the top and the rest of the messages are events or sponsorships or whatever that might be. So I'm not sure it matters. It's just if you stayed with a percentage, I think roughly 80 would be. I think I'll look at these guys to see if that makes sense.
It doesn't make sense if it's not based on anything.
No, in that case, it'd be based on just the thought that up to 80 means that it says, hey, we presume you're going to need some static, or we want to require some static area, but it honestly doesn't matter. You could say 100%, and then in the designer, they would decide if they wanted static area versus all digital. So it really probably doesn't matter too much.
Well, I think the smaller the static area, the smaller the frame, the less obtrusive it looks in a residential area.
It only matters from the standpoint that the current limitation is 50%, and if you're going to grant an exception to the 50%, as city manager mentioned, if you want to make it 100%, you can, but if you're going to have some ratio, then at 160 square feet, 128 is exactly 80% of the sign area.
It helped. The percentage would help you to stay within the structure of how it's dealt with today until such time as a text amendment could go back through, and then you could change your methodology.
Is 128 a 4x3?
So what would you need to keep it formatted at the right ratio?
Well, and I'm far from a graphic engineer, but the standard is a 4x3, so anything, 16 by 9 would be divisible in that increment. So again, it's not unreasonable for us to do that work, it's just extra time and energy to get to the point to where we resize each of the images to accommodate, but, I mean, it's not unreasonable to ask that by any stretch.
Okay, and 16 by 9 would be 80% of how large of the sign? Surely there's a math major here somewhere.
I think it was, the original request was 176 for the overall sign size, and I believe it was 82% was the 144. So we were close, but we weren't quite at 80, I guess.
See, that's 9 by 16 is 144.
Yeah.
Well, you don't want things to look out of proportion on a screen either. That's the other part. You have there are unintended consequences to some of these numbers we're throwing out. I don't know what all they are. And one of them may be you have to take every image and message that you want to put up there and modify it. And I don't know if that's good business either. I think keeping to the 16 by 9 is probably the reasonable way to go if we're really serious about a sign. Whatever the dimensions are, keep it 16 by 9.
And just work on the spray of the light.
Yeah.
Yeah, if it were on your street, it would make
Well, don't do the sign then.
Well, I'm just saying.
Well, I think
we've already done the midway.
I think that I think the important thing is in here is I think that's part of it, and that is what's the minimum effective size?
Yeah.
If it's 128,
well, if it's 16, whatever 16
then
by
it's,
9
do you
comes
want to
up
do a
to.
sign or not do a sign?
Yeah, well,
I mean, it comes down to that. I mean, that turns out
if
to
it can't be 16 by 9, it may be a problem.
Yeah.
Do the panels come in prefab sizes, or can you? And if ours just happened, I'm gonna throw out a number: 7.5 by 13.5 feet. Can they be made that way, or are they prefab?
Yes, they are custom made to the design.
So we could
Panels are.
set a
Panels are
size.
custom made to the design size of the board.
So
They're
not,
typically nominal because you maintain that 4:3 ratio, but they're custom designed to the sign.
Let me ask this question: for consideration of square footage of a sign, say there's a video screen with a minimal frame around it. If there were letters that said Salina Bicentennial Center on the added to the top, but the sign didn't go all the way across, it just added to the top, how would you calculate that square footage? It's by the area that the letter occupies?
Yeah, you'd have to, I mean, again, it goes back to the distance that you'd be able to read the name. And then in that case, that's a lot of letters there. You would You would determine the letter size based on the distance to read it, and then however many letters side by side with proper spacing, and then you'd come up with well, it needs to be this wide.
Dimension-wise, what would be the next size down from 128 square feet? What would be the next smallest increment to say 100 and, well, 96, 128? What would be the next?
They said they wouldn't do anything under 128. I think he said.
No, 128 was the,
Well, here's
felt
the
to be
thing.
the minimum size.
Let me go about this front. Is that the only type of sign we can do? I mean, if the digital display sign in that configuration, 128 is the minimum, is that our only option?
If you want changeable messages.
And that's probably a question for Ron. I mean, is that?
You go out and put the letters up with a ladder.
I'm only laughing. It's like,
It was funny.
don't encourage him.
You could have somebody behind there just changing the score.
We go with the.
Well, we about beat this to death, so.
Yeah. Maybe we go with the planning commission.
I would say it's
I'm only
important.
voting, I'm not making motions, so I'll wait for whoever's.
I was just going to make, and this, it's probably the linchpin of the whole thing, but the planning commission made a finding that that it could potentially have an adverse effect, and so if you were to approve the larger sign size, you would just need to conclude that having the larger digital sign size would not have an adverse impact on the adjacent properties, and that would be the primary distinction between their recommendation and what you would consider today.
I don't think I understood what you meant. What you meant by
Well,
that.
the reason
They're
that
finding a fact.
the planning commission declined to approve the total 176 square foot sign and the 82% digital was because of the residential setting and the homes across the street. They thought it would have an adverse effect, and so they if you don't agree with that conclusion that a sign at this size, location, and configuration would have an adverse effect, that would be your basis for having a different conclusion than they reached.
So if we were to change this to a screen size of 128 square feet,
Leave the size of the sign, the overall size the same, make the changeable copy 128, which is the engineer's recommendation. Is that his minimum recommendation?
No, I think the architect recommended the 9 by 16. The 128 number came from some of the research that was done for a 40-mile-an-hour street like Ohio to have it visible that the minimum size you needed was 128 square feet. That was a conclusion that planning staff reached based on looking at the research that had been done. So that was based on some planning literature that given a 5-lane street, 40-mile-an-hour traffic to be effective, the minimum sign size needed to be 128 square feet to be visible and readable. But the design architect for the project felt that 9 by 16, 144 square feet was the minimum digital size needed to be effective.
Well, it's one step closer.
Yeah,
And if we
one step
initiate a
closer.
text amendment to study this, then it'll be a little more in line with the 50% that sits now.
so the big question is, do we want the 128 or the 144?
Well, the 144 is the 6 by
16,
19.
I'm
Or
comfortable with
16 by 9.
I'm comfortable with 128.
I'm comfortable with that.
The planning commission agreed that you could see that 40 mile an hour. That's the way I understood it anyway.
I didn't hear that.
I said, I'm comfortable with the 128.
Is 128
think.
4x3?
No.
Okay. And see, for that reason, then I'd rather go up to 144. If the 128 is not workable,
They said it was the minimum.
Well,
as far as the formatting.
If you want to keep the same format, the 16 by 9 format,
4x3.
which I would imagine is important.
I think they'll build it anyway, we tell them to.
Yeah, I don't think so.
Well, they will, but okay. You take your TV set, if you have a whatever TV it is, and you have an old program on there. You're going to have black bars on the sides.
Commissioners, and we were starting to wonder if the evening's wearing on here, but
On me.
the way I learned to do math, 9 is 3 by 3 by 3.
Yeah.
Add another 3, so you have 3 3s and 4 3s. That's 9 by 12. 9 by 16 is not a 4-to-3 ratio.
It's true,
You're
actually.
correct on a horizontal format.
Right, it would
I
be
think
9 by
mine big.
12.
I mean,
yeah.
instead of going vertical, you're talking, yeah.
Yeah,
Yeah.
that's true.
Didn't want to disrupt your math, but I just thought I'd share it.
So how about 9 by 12? But no, wait. No, not 9 by 12.
Well, 9 by 12 would be a 4-to-3
That would,
relationship.
That's
but
108 square
that's
feet.
108, but that would be too small.
Well,
That's the reason I say if it's truly customizable, it's just that next size up. But
yeah, I
Might
do
need a
I do
few
believe in
minutes
this.
to
The width
figure
is
it out.
pretty important compared to the height. I agree with that. Whatever ratio that needs to be, those guys could probably help a little bit more with that. But
I'd say that the choice would be between 108 and 144 if you're going to keep the ratio the same.
or whatever the next size down from one. I mean, there has to be something in the middle if you can customize it. But
Well,
I just-
but all of a sudden, then you're going to see some black bars on the sides of the sign, or whatever, because the image won't fit exactly anymore.
Talking about,
I mean, if it's 11 feet across, then whatever that number up to keep it the same ratio. And I could figure it out, but just take a minute.
are you,
Well, but that's what, we have a planning commission for. to do
wouldn't
this
your
stuff.
16 by 9 though just be one more? Wouldn't it make it more of a letterbox
4
versus
into
a?
33.
yeah, I think so.
Is that the format? Is it more of a letterbox type?
Okay,
Well,
I mean,
it's
not
4 by
letterbox, but you know what I'm
3.
talking
Well,
about.
it would be 11 by 8
by 9 is 4 by 3.
or 11 by 8.25.
Is that standard format?
Yeah.
And the old format then was what he's talking about, 12.
That's the same. It's 4 by 3. A 9 by 12.
Or
They're
something.
both the same ratio.
I think on televisions, they call it 16 by 9.
With
Well,
the-
one's
you get the same
elongated
man.
more. One of them's more of a new TV. The
Yeah,
other
right.
one's like old TV.
yeah,
Are
with
we
the
going new TV?
with a little help from Google, the high def type ratios of that is a 16 by 9 or 9 by 16 ratio. I imagine that's where this probably came from. So whether you go up, which I don't think we're going there, or go down, I think you'd want to keep that ratio. Does that make sense, guys?
So what would be the? And do you have to do it in those increments? I mean, is that what we're looking at? That somehow it has to be in that increment?
Kind of outside my field here.
Because what I'm trying to get at is, am I looking at a
Outside our field, too.
52-inch versus a 46-inch TV versus a 32-inch TV? You know what I'm saying? It's not like I take one chunk out of that and I go from a 52 to a 32. And so I'm just wondering what the
Yeah,
are
commissioners.
are there standard sizes that these screens are generally configured in that we're looking at 120,
I-
128 for a
I think
reason?
there may be. I would, at this point, I think we want to be right. on that. I don't want you to guess on this type of action, and possibly an action would be to go ahead and postpone this item and continue. You close the public hearing. I don't know whether they need to go ahead and continue the public hearing anyway,
Well,
Greg.
actually, 14 by 8 is a little fraction, but it works out to the same ratio as 16.
Yeah, we just don't have the folks who are experts in the video graphics aspect. We just don't have those people. We could probably get that answer pretty quickly and be able to come back and tell you exactly within the realm of what you're talking about tonight what that needs to be. I just wouldn't want to guess and guess wrong. So
Can we? Who do we need to get here to do that?
we could probably, if we just postponed it a week, we could get you the answer. Even whether they're
Okay.
here or not, we could find out for you.
All right.
And be a little more prepared from that perspective.
Okay.
And during that week, we'd be able to find out about the recessed
Yes. Yeah.
screen.
Shields on the side or something.
Or how much spillover there is. Maybe how much spill there is at different depths or whatever.
Mayor and Commissioners, while a public hearing is usually conducted in association with these first readings, it is not a formally noticed public hearing as such. So if you wish to postpone first reading of the ordinance until whenever works,
Okay.
that's certainly your prerogative.
Mr. Mayor, I'd like to move to postpone the first reading of ordinance 15-10810
Mhm.
until next Monday's meeting, which would be I have no idea.
November 2nd?
November 2nd. Thank you.
Okay, do I have a second?
Second.
Okay, motion and a second to postpone first reading of ordinance number 15-10810 until November 2nd, 2015. Any further discussion? This, of course, is to give staff an opportunity to compile more information on this item. Okay, all those in favor?
Aye.
Aye. Opposed? That carries 5-0. This will, ordinance 15-10810, we'll take that up again next week. Thank you, ladies, for coming.
Can I ask a question?
Please.
Why can't they do 100% of the 100 square feet instead of that 50%, the 82%? What he's saying, if you're talking about that stupid television, why can't you go 100% of 100 square feet?
Okay. And the question was, just for the folks at home, why can't we go 100% of the 100
I
square
think we
feet?
can can check. I'm assuming that you can have a freestanding all digital sign and you don't need to have the structural border. I don't know that. You wouldn't have the ability to do the inset that way, but I'm assuming there's a possibility you could do that. We can ask the question.
Okay. Those are part of the questions that'll be, we're going to find out is what are the different size options that are actually
But we've
configurations.
asked that twice now, and
Yeah,
it's
well-
still coming back to the same.
Well, we just got this today, so the
That's
best
why
we can do is-
government goes
yeah.
so slow.
Well, 3 meetings on the other one, so.
Yeah, we'll get an answer back.
Okay, thanks. Okay, we'll move into other business now.
Commissioners, I have one quick one, and you don't necessarily have to do anything tonight, but I was reminded from our Access TV general manager that under our agreement, there is a section in there, Section 25, that deals with the board liaison, and it says each party agrees to execute, well, I'll skip it. The city anticipates appointing either a member of its governing body or a Salina citizen as a liaison between the governing body of the city and the Access Board of Directors. We haven't done that yet. Again, it says either citizen or one of you guys or gals, and it would be a similar role as your other liaison type roles with other boards. But
Mhm.
just wanted to bring that up. You don't have to decide that today, but I wanted to bring that to your attention.
Okay, would you find out for us when their board meets?
Yes, I will.
Okay. And then we'll be able to determine whether one of us is able and willing, or if we find someone else. It might be just easier for one of us to do that. So, okay.
More business?
Other business?
We do have need for what I think will be a short executive session. I would think 10 minutes.
Okay. Great.
attorney-client
You
privilege.
better make it more than 10 minutes.
Yes,
We
it
never
is.
do anything.
Then, Mr. Mayor, I would move to recess into executive session for 10 minutes to discuss with legal counsel matters subject to the attorney-client privilege for the reason that public discussion of those matters would waive the privilege and adversely affect the city's interest in the matters, and reconvene at 8:25.
Second.
Okay, motion and a second to recess into executive session for 10 minutes and reconvene at 8:25. Is there any business following?
No.
No, we don't anticipate that.
No business anticipated. Okay. All those in favor?
Aye.
Aye. Okay, that passes 5-0.